Yes, Mr. Lord.
If it is not inconvenient to your lordships, item number 34 and 35,
What is that?
that's a matter can be, if your lordships kind enough to take a matter.
Oh, this matter has come back.
Yes, ma'am. So at 2 o'clock, if it is possible.
Have it at 2.
Yes, I'm deeply obliged.
May please, your lordship. For listing of an interlocutory application, correction of my lord's order, some typological error.
Which one?
Any day this week, my lord.
Which one?
My lord, that one SAO was disposed of by my lord. In the order, my lord, the appellant has been mentioned as a dead person.
Then
My lord, it was,
it is not so.
my lord,
It is not so.
is it not? It is not so.
So you are filing a review.
My lord, I'm filing a, my lord, I am, my lord, for correction of that typological error.
Otherwise, it's okay.
Okay.
Okay. We'll have it on
Thursday, my lord.
Thursday.
And so,
Wait, please, your lordship, I beg to mention item number 20. A joint prayer is made, your lordship, as Mr. G.N. Sahavan, senior counsel, is unwell after pleading in the courtroom yesterday.
Item number 20. The request of the learned counsel appearing on behalf of the petitioner matters to adjourn to be listed up.
Your lordship, a similar prayer for series item 8 to 12.
Why? That day only I was supposed to dismiss it.
Your lordship,
Nothing remains. No, nothing doing. This matter has been heard out there. Your senior has been heard. On that day, I've already heard your senior. I've also heard Mr. Kane Chaudhary on this. I've only asked them to get one information. So don't come up with this type of.
My lord, item number 20, the date may be fixed on, must not be fixed on 27, my lord.
Why?
My senior has some another matter, another plans.
Come after vacation.
After vacation, but 27 January will not be possible for my seniors.
Huh?
27 January.
Not possible. Okay.
Okay, after vacation.
Request of the learned counsel for the petitioner matters to adjourn to be listed in the first week of February.
your lordship, I'm for the petitioner.
You are requesting.
Request.
Who is asking for the adjournment? Item number 20.
She's asking for the date.
I'm not giving a date. I'm putting it after in the first week of February.
With your lordship, item number 15, your lordship.
Yes.
We seek to withdraw the repetition with liberty, your lordship. Withdraw the liberty.
You want to withdraw with liberty.
I'm for the response number 3. On same period, item number 21 and 22 in other occasion and lordship has passed an order. I just supply.
But these two,
But this is the
These
order-
two
this is the
remain.
Procedural matter. Land acquisition matter. So
item
on,
21 and 22,
this is the same.
same order like this, huh? It will be disposed of. And item number,
15, your lordship.
you are for that, those applicants, nah? The land, whose land has been taken. So, okay. You see, we have delivered a recent judgment of in the division bench, me and Justice Midul Kolita, in respect to a group of matters pertaining to Mizoram. Have a look at that. I think we delivered just before I left on 28th of 28th, no? 30th. November, 29th of November. Have a look at the judgment. Both of you. And 2 o'clock, 15 to o'clock. Mr. A.R. Gogoi, the learned counsel appearing on behalf of the National Hydro Power Corporation Limited, who is the petitioner, admits that he has instructions to withdraw the instant writ petition, taking into account that various formal defects are there which needs to be which needs certain correction, which needs to be rectified. He therefore submits that he may be permitted to withdraw the petition with the liberty to refile. Taking into account the above, now, this court had also heard the learned counsel appearing on behalf of the respondents. Taking into account the above, this court, the incident with petition stands closed on withdrawal. Petitioner, however, would be at liberty to refile by removing those formal defects.
Congratulations.
Lordship, the consent of others that I beg to mention item number 30, Lordship, or reconstruct a file, your Lordship.
What?
Reconstruct a file, your Lordship.
You want to reconstruct your file. You are for the petitioner.
She responded.
Respondent wants a reconstruction. He will give you a copy. Matter over. Give a copy.
I will give the copy, Lordship. For the only thing, Lordship, yesterday they informed me, in this case, Lordship, as per earlier order of this honorable court, respondents are to file their affidavit in opposition. And earlier, Mr. M.K. Devnath used to appear, but he now he is not in the department. So
Is left practice.
Lordship.
Left practice for good.
they does not have the file.
And he didn't hand over the file while leaving.
Displace the file.
And so appearing on behalf of the
PNRD department, Lordship, S. Dr. Lordship.
PNRD department submits that the earlier counsel, standing counsel of the PNRD department have left practice
Lordship.
and did not hand over the file, and as such she requires some more time for obtaining for reconstructing the file. The learned counsel appearing on behalf of the petitioner is directed to provide a copy of the writ petition during the course of the day. This matter after 6 weeks. In the meantime, affidavits be exchanged.
I'm obliged.
Obliged, Lordship.
Top of the list, item 1.
Yeah.
Oh, Mr. Chaudhary, this matter has traveled from here to division bench and has come back.
My lord, everything was triggered by respondent number 4, my lord. I'll show their bona fide limit.
Huh?
Their entire case, I understand on last occasion an argument was also made that we have not challenged the order of the Board of Revenue. My lord, the fact of the matter is when we moved this petition, we could not annex it. We have made specific averments. Subsequently, by filing the affidavit, they themselves brought on record the order of the Assam Board of Revenue. That is how, my lord, we did not bring it to record. But then since it was on record and we have already challenged it, there are specific averments. Therefore, that was not a necessary, requirement. Now, the whole case is, my lord, this particular unit manufacturing ACC block, my lord, it is in DUG number 95. It is not in DUG number 35. And everything was triggered by respondent number 5, who claims that on their death we have encroached upon their land.
What is the finding of the DC?
My lord, if your lordship, at page 156 of the affidavit is the order of the Board of Revenue, my lord. My lord, before that, can I just show one thing, my lord?
Yes.
End of the day, it's a dispute regarding a private land, patta land. Therefore, if at all one has to take recourse to, one has to go to the civil court. My lord, before that, if your lordship could kindly take the affidavit filed by the, my lord, respondent number 5, page number.
We are concerned with which order, what you are challenging out here.
We have challenged initially that Deputy Commissioner's order.
Is
which was carried in appeal
it
before the-
6/9/2021?
Yes, my lord,
Page is 250.
of the writ petition.
Yes. It has been observed that you are in possession of the below.
Page 251.
And by running an industrial.
Now, if your lordship would kindly come to page 252, my lord.
Yes.
Now, this is the bone of contention. Whereas during the time first subpara, whereas during the time fixed for hearing, both parties were present with their learned advocate and deposed their statement along with the documentary evidence in support of their claim. On behalf of Messrs. Superlight AAC Block Industry, learned advocate stated they had executed an agreement for sale with Srimati Kardam so-and-so for an area of land measuring 16 bigha bearing in Dag number so-and-so, situated at village under so-and-so before Notary Public Metro. The learned advocate also alleged that Kardam KP also executed a general power of attorney before the senior sub-registrar Guwahati on 7th of June 2018 and nominated and appointed one Ajoy Mahato, son of Pujanlal Mahato, as the true and lawful attorney for an area of land measuring 10 bigha covered by Dag number 35 under KP Patta number so-and-so of Khorutari under Sonapur Revenue Circle. As such, they had paid a sizable amount of money as advance to Ajay Mahato, the power of attorney holder on behalf of Srimati Kardam KP. During hearing, the learned advocate on behalf of Superlight Industry also stated that till they have not applied to obtain NOC to purchase the land for which they executed the agreement of sale. Whereas Circle Officer Sonapur Revenue Circle has clearly reported that Superlight so-and-so is located in an area of land measuring 16 bigha of Dag number so-and-so, where they have no ownership by dint of their names and having not been mutated in land records till then. Whereas while pursuing the existing land records of Dag number 35 under KP Patta number 30 of Khorutari under Sonapur Revenue Circle, it is seen and observed that land in question is still in the name of Srimati Kardam KP, along with Kardam KP is the mother of Milord respondent number 5 and mother-in-law of the gentleman called Ajay Mahato, who are espousing the cause of tribals with 4 other co-pattadars. The said land has not been mutated in favor of Superlight ad hoc so. Further, the land in question, where Superlight ACC Block Industry is located, has not been reclassified to industrial class of land based on land use pattern. Whereas from the above, it can be ascertained that proprietor of Messrs. Superlight AAC Block Industry has never purchased the below mentioned scheduled land where the said industry is located. Merely executing an agreement for sale of land does not confer any eligibility to get ownership of the land or to get mutation over the said land. However, the agreement of sale as executed by Superlight Block with recorded pattada is not a registered one, rather it is a notarized one. Again, as below mentioned, scheduled land is located inside Sub-Kamrup tribal belt. Therefore, a Superlight AAC Block Industry is in violation of the provisions laid down in Chapter 10 of the Assam Land Revenue Regulation by illegally possessing the said land without valid document. Further, Superlight AAC Block Industry is running their industry without reclassifying the land to the desired class of land, which is resulting in loss of government revenue, as government revenue of industrial land is much higher. From the above, it can be concluded that proprietor representing Messrs. Superlight has entered into occupation by setting up an industrial inside the tribal belt without any valid authority and without purchasing the land or without fulfilling the para 17.2 and 17.5 of the land policy. Thus, they have violated the provisions of Chapter 10 of the Assam Land and Revenue Regulation. There, as per provisions of 165(3)(a) of the Chapter 10 of the regulation, I, Biswajit Pegu, IAS, Deputy Commissioner, Metropolitan Order, evict Superlight Industry from a mentioned scheduled land as per the procedure. Now, scheduled land is so-and-so covered by Dag number so-and-so. Now, my Lord, Lordship will kindly, for a moment, please come to the affidavit filed by respondent number 5. Now, please have page number 101. This is an LS sale deed based on which, my Lord, they claim title over the land.
10?
this page 101 of the affidavit.
Affidavit. Running page. Affidavit filed by them.
Filed by respondent number 5. Serial number 355. Now kindly on top, my lord, deed number 6454 of 89, and this is dated 27/12/89, as would be evident from the main copy. Now, this deed of sale of land is executed to the following effect in favor of Cardam K. Api by so and so, so and so. Now by Stanley Nicholas Roy. Whereas we, the vendors, were in need of money, we propose to sell a plot of land which has been under our name and possession a plot of land measuring 16 bigger, 13 lessers and described in schedule below. Whereupon you agreed to purchase the said area of land and on receipt of proper value consideration of so and so, only in cash and got written in the sale deed and handed over the possession of the. Anyway, my lord, the fact of the matter is this 16 bigger, 13 lessers of land covered by DAG number 35 of KP Potta number 6 of Korutari village was purportedly purchased by Milord, respondent number 5's mother, from the vendor Stanley Nicholas Roy. My lord, most importantly, Milord, this DAG number 35 was not in existence in the year 1989. This was created subsequently, my lord.
But the patta number is also different.
Yes.
Patta
My lord,
number is
kindly come to the writ petition, my lord. Please come to page number 1204. First, my lord will kindly come to page 189. That's a forced document. My lord.
Yes.
Page 189, my lord. Ungo. As per order of circle officer dated 4th of January 2005, page 189 of the resolution. It's a part of the Jamabandi, translated copy.
Yes. Tell me.
Ungo. As per order of the circle officer dated 4/1/2005, pursuant to the order of the ADC Kamrup dated 30/12/2004, made in partition case number 69 of 2004-5, an area of land measuring 50 bigha has been partitioned among pattadars, namely Meridendu, Nicholas Roy, Cynthia, Barbara, Swen Nicholas, all children of Stanley Nicholas Roy, by creating a new patta being 30 corresponding to the Bangla year so and so. This 50 bigha of land includes 3 bigha, 2 katha, 15 lessers in DAG number 33 of Patta number 6. Now this is important. 26 bigha, 13 lessa in DAG number 35, 3 katha, lessa, etc. etc. So, my lord, pursuant to this partition case in so and so, this new DAG was created in the year 2004-5. In 89, where from they got their DAG 35, my lord? And
It may be there.
Eh?
It may be there.
No, it was not there, my lord.
No, it may be there.
Now I'll show, my lord, why there cannot be any such land. Now, if a lordship would kindly come to page number 204. Page
Where's the
204, it's
original
part
of
of the
187?
Jamabandi.
Where is the original of 187?
Yes.
So page 193.
One second. Yes,
193, it therefore shows that these are the dogs which were there in that patta.
Hmm.
It didn't have 35.
yes. Now, no, my lord, everything will be clear from page 204. And I'll place 2-3 orders, my lord, wherefrom it will be clearly evident that their claim is, my lord, based on falsehood. Page 204. Kindly come to serial number 3, Barbara Nicholas Roy, 35 bigha, dag number 26
But
bigha.
this
13
happened because this is subsequent to 2005.
Now, my lord, why
therefore-
they cannot own the land? Please come to page 205. Now, out of this 50 bigha, what had happened, Miller? Kindly see page 205. Old dag number was Millard 9 and patta number was 6. Now it is 35 new. 35 is the dag number and 30 is the patta number. As per the direction of the circle officer pursuant to the order of the learned ADC Kamrup dated 30/12/14, so passed in partition case number so and so, a separate patta being patta number 30 corresponding to Bangla year has been issued in the name of the pattadar so and so, so and so, so and so. In respect of the total land measuring 50 bigha of patta number 6% to village Horutari under Hunapur Muza. This 50 bigha of land includes 3 bigha, 2 katha, 15 lesa in dag number 33, and we are concerned with Millard, 26 bigha, 13 lesa in dag number 35. Now please come to the second endorsement. As per order dated 27/4/09 of the circle officer, on the basis of the sale deed and possession, mutation has been done in the name of Sri Kamal Tumung as representative of Messrs. Sukreshwar Alloy as the director along with Patara number so and so. So in respect of 10, this was done. Then by subsequent endorsement, it was cancelled, Miller. As per circle officers, Sita mutation so affected in the name of Kamal Tumung in respect of 10 bigha of land, it has been cancelled. Now kindly come to page 206. This three endorsement will show that there could not have been 16 bighas of land for her. As per the order dated 28/3/11 of circle officer passed in mutation case number so and so, name of Kamal Turung, son of so and so, mutated on the basis of sale deed and possession on behalf of Shivam Ferroloi as the director along with other pattadar so and so, so and so, so and so, in respect of 10 bighas of land in dag number 35. So out of 26 bigha, my lord, 10 bigha is gone.
Mr. Chaudhary will go to that. The fact is, how do you have any right? First you show.
Now my right flows from my sale deed.
Hmm?
Sale deed.
They live where?
Yes. Page 158 of the writ petition. So, my lord, why I was trying to show this aspect, because everything was triggered by them.
Let us first see.
Yes,
Okay.
page 158.
So in 2010,
Yes,
Kalyani Properties purchased it.
yes.
And who are you?
My lord, subsequently it has come to us, my lord. Mukul S. Lemare is the director of our company. Actually, my lord, initially we had only one tribal director, but today, my lord, all the directors of the company are tribal directors. So that non-tribal aspect will also not come. And kindly see, my lord, the sale permission at page number 171. Transfer of land by way of sale, gift, so and so, so and so, for issuance of NOC. This is to certify that Deputy Commissioner Kamrup
So
Metro.
this is a different patta.
Yes, we are in 95. Where they claim.
No, they are not claiming. The question is,
Yes, our case is, my
the
lord,
question is, the circle officer had given a report that you are in 35.
30.
Now, if you are in 35, but your land is in 95, it's only a question we are to believe the circle officer's report.
No, my lord, my humble submission is that is also not correct for the simple reason My lord, it is not the case of respondent number 5 that they are not in possession of the land. It's not their case that we have dispossessed them. My lord, during that 2004-5 exercise, some mistake has occurred somewhere, my lord. That is what we apprehend.
Where have you gone for correction?
My lord.
Where have you gone for
Yes,
correction?
we have applied.
So in the map, it would be shown which land you are in.
Lord, will kindly see, when we set up the industry, all conceivable permissions we have taken.
That is a
And each
different
and
thing.
every permission in respect
No,
of-
whatever may be, you
Yes.
may have a land out there in dark number 95 or KP Pata number 20. But the fact we are in consideration out here as regard dark number 35 or Pata number 30. Now, whether the fact that it is a tribal belt is not an issue. Number two, if you have no right over that land, you have a right over 95 and not of 35. Therefore, you have no right to remain out there.
This is not the case of the circle officer that we have set up the unit in
That
by
is
dispossessing
no,
somebody.
that is from the impugn order.
No,
It appears.
No, my lord, we kindly see, right from day one.
Kindly come to page 252.
Yes,
Whereas the circle officer Sunapur Revenue Circle has clearly reported that so-and-so is located in an area of 16 bighas bearing dark number 35 under KP Pata number 30.
yes.
So if this is a fact which is there,
My
then
lord,
you cannot be there.
this is a finding of fact which we challenge before the Board of Revenue.
The Board of
Board of
Revenue
Revenue
also,
did not do anything, my lord, on this.
let us see what the,
Yes, my lord, kindly see, my lord.
where is the Board of Revenue's order?
My lord, that is in page 160.
It's 410, my lord.
6 of the, my lord,
410.
10.
if your lordship could kindly come to, my lord, para 11 of the order of the tribunal.
Yes.
Now, para 11, he also states that sale deed dated so-and-so, dated 27/12/89, between Stanley Nicholas Roy as seller and respondent mother Ardam K. Api as the purchaser is the only genuine and valid sale deed, and totally denies the validity of the sale deed which has been furnished in the memo of appeal, in which the land has been sold to Ardam K. Api by so-and-so, exercising power of attorney on behalf of Stanley Nicholas Roy. So, my lord, tribunal proceeds on the basis that the sale deed dated 6/4/54 of 89 is the document which conferred them title. Then, my lord, will kindly come to paragraph. Yes. Para 12 onwards. Now, after this, my lord, there is no discussion on this. He also states that section 157 of chapter 10 of Assam Land Revenue Regulation bars the civil court to exercise any jurisdiction in matter covered under this chapter. He therefore contends that Deputy Commissioner has lawfully exercised his power under section 165(3)(a), which authorizes him to evict any person who enters into occupation of tribal land without any valid authority from the landholder or comes into possession of the land which is consistent with the provisions of chapter 10, which seeks to provide protection to classes of people who are clearly disadvantaged to look after their own welfare. He also cites various judgments of the Honorable Guwahati High Court in support of the contention. Then he refers to para 17.4 of the land policy, my lord. In para 13, he cites another judgment, Dinanath Brahma. Now, my lord, para 16. Para 15, sorry. He also disowned the validity of the notarized affidavit cum NOC furnished in the memo in which the applicant has purportedly allowed Superlight to operate and in which she has stated that she would be executing a sale deed soon. He states that the said affidavit has never been produced before any authority, including the circle officer. He also states that property holdings were 96%.
Now, why do you have an agreement for sale?
No, that was there, my lord, that never effectuated. We are
No,
not
isn't
even-
it
we are
your
not
case
breaking
about
out of
the,
that. My lord, the Board of Revenue should have dealt with this aspect. It was our specific case. They have not. Kindly see, now page 16, then para 17 is there. Only, the view taken by the learned Board of Revenue was that this is a tribal land, you are a non-tribal, therefore you can't be there. That we are in doc number 95, that we are not in 35, a finding of fact which ought to have been gone into by the tribunal. There's absolutely nothing. And prima facie, my lord, I have shown this sale deed of 89 is a false document. Because in the year 89, doc number 35 was not even created.
so why did you have an agreement for sale?
Well, that we entered into, my lord, we are a businessman.
Can you approve it and reprove it?
It's not a question of, that is a point which we
The
are not
entire
making.
case has been based on that. Where is your ground of objection as regards that opinion of the circle officer
Yes.
in
before
your,
the-
in your
before the-
memo of appeal?
Yes, my lord.
Your memo of appeal, the ground of objection
One
starts from page
that-
384.
If your lordship should kindly come to para number 24, my lord. Para 24, page 27.
Of your petition.
Yes,
No, I'm saying about your grounds of objection before the Board of Revenue.
1 second, my lord.
Because that is the crux of the matter,
Yes.
that if your land, you are in occupation, let us not touch on your sale deed. You have a sale deed of
Lord,
so and so.
That we have highlighted in para 24, if you kindly permits me, at page 27.
Yes.
That the petitioner states that the learned Assam Board of Revenue committed material irregularity in evaluating the facts of the case in its proper perspective. As explained herein above, industrial unit was set up in the plot of land measuring 21 biga 4 quarter 17 lessa covered by doc number 95 of KP Patta number so and so, purchased by Mukul S. Lamare, a notified tribal after obtaining requisite permission from different authorities. It is pertinent to state herein that aforesaid doc number 35 corresponding to KP number 20 was
Yeah,
carved out-
Mr. Chaudhary, you clearly admit there is no dispute
Huh.
that the mother of the respondent had purchased among other a plot of land. So now how can you, this is the pleading, how can you argue that you are denying the title on the basis of the sale deed?
No, my lord, that's not our case. Our case.
No, isn't it your statement in on affidavit stating out here that there is no dispute that the mother of the respondent number 5
Huh.
that she purchased another amongst other a plot of land of 16 because of so and so,
Huh.
so and so, so and so, so and so. It is the result that the
No,
industrial unit was
Please,
set
please,
up in
please
Kenya.
read below, my lord. It is the case of the respondent number 5 that the industrial unit was set up by the petitioner firm is in doc number 35 and Assam Lar Board of Revenue also proceeded on the same premise, thereby committed a serious error in adjudicating the list. The documents annexed to the writ petition would clearly establish that industrial unit was set up in land so and so covered by doc number. It is only an allegation of respondent number 5 that industry partly falls in the doc number 35. Since the said dispute pertains to Miyadi Patta land, in law the remedy lies in appropriate forum and in invoking provisions of chapter 10 was unwarranted. It is reiterated the industry was set up in the land purchased by Mukul S. Lamare in doc number 95 after obtaining permission from the Deputy Commissioner for purchase of land in South Kamrup Tribal Belt. Additionally, requisite permissions were obtained from different authorities. So, my lord, these are a clear case.
So
The
therefore,
same points were asked before the Board of Revenue also.
therefore you clearly admit the sale deed.
Yes, my lord.
So you cannot say about the sale deed being bad of the respondent number 5's mother.
No, we say, my lord,
Your
in
basic is
89, that doc number 35 was not even there.
now you are saying it
Huh.
on argument, but on affidavit you have admitted of the sale deed. That
No.
is yes.
But But no, Lordship will have to read the facts in the totality.
No,
That's
but you
express
have
content
categorically
logic is not
admitted
written
in paragraph
isolation.
number 27,
Yes,
24, 1.
yes.
Secondly, you say that the Board of Revenue made a mistake on just an allegation, but the Board of Revenue also dealt with, and the DC
So
also
Board of
dealt
Revenue
with on the
dealt-
circle officer's report.
Read the revenue's order. There's not a whisper on this point.
No, but where is the challenge to the circle officer's report?
Well, we have said,
Where? Because your basic contention of here is as regards the circle
one
officer's
second, my
report.
lord. Heavy appeal copy to me.
Yes, who is paying for the revenue?
Board of Revenue copy to me.
Yes, madam.
You're there. In this case, what is your action? You have made a report out there. The entire crux of the issue is whether the industry falls in 95 or 35. The circle officer's report makes it clear that it is 35.
35.
That is the issue. Why should we go here and there? Where is the challenge to the circle officer's report?
My lord, in the Assam Board of Revenue, my lord, we have raised all these points. Somehow, my lord, I am not finding the copy.
Page 2, 384 is your 384 is your memo of appeal,
One second.
the grounds.
Yes, copy of the memo of appeal 113.
Now, page 380, running page 384 or 130.
Yes.
You'll find the grounds of objection. Finally, see number 7. Page 132.
Yes, my lord. Appellant began, it has never intended nor been endeavored to acquire ownership right over the land concerned in view of the fact that one of its partner, namely, is the absolute owner and title of said land. Though mistake and error was committed while allocation of land under aforesaid Doc number 95 and 35 by revenue official during settlement in land sealing proceeding, those error or mistake can be rectified and corrected by respondent authority through proper will verification and survey of land. As such, the impugned order and notice issued therein are liable to be set aside and quashed.
So your entire case of this voluminous file boils down to a simple fact as to whether your land lies in 35 or 95.
And my lord, to that,
And there is the verification given by the circle officer.
but to that, my lord, the learned tribunal has not dealt with. That was our
You have
specific case.
also, with due respect, have not clearly spelled out.
No, my lord, it's our case in so many words.
Like your argument also does not say anything to that effect. So the issue therefore boils down to that, and that this particular observation of the circle officer makes the entire case.
Yes.
Page 252, whereas the circle officer has clearly reported.
Yes.
Now, this is the main problem which you are
No,
having.
my lord, I admit, my lord, that is what I have to overcome. But to that we laid a challenge. But the authority with
And the
supposed to deal
challenge
with the
which-
facts and law did not deal with it.
And the challenge you made, which was negative or not taken into consideration by the learned Board of Revenue,
Yes.
that order is also not under challenge.
No, my lord, that Board of Revenue's order is under challenge.
No,
Yes.
you
Yes.
said the Board of Revenue has been wrong.
No, my lord, what had happened? Now, if your lordship will kindly permit me to place one paragraph, why we have to take that stand? Please come to para 21 of the writ petition.
Paragraph 27, 24 also, you categorically
No, my lord,
say
why?
that the
under
petitioner
what
that the Board of Revenue
circumstances-
committed material irregularity.
No, my lord.
All
Para
these-
21, please come to para 21.
Yes.
at page 25. 6th line from the bottom. The petitioner preferred a statutory appeal before the Assam Board of Revenue, being case number so and so, but the aforesaid appeal was also dismissed by the chairman. by
Mr.
the
Chaudhary,
order
what,
under this
what
one.
appeal you have preferred under 147?
Yes. Kindly say, my lord, due to paucity of time, the certified copy of the aforesaid order could not be obtained and annexed to the present petition, and same would be filed later on as and when supplied by the registry of the Assam Board of Revenue. So on the date of moving the writ petition, my lord, because we are expecting that the whole thing may be evicted, so we moved immediately. And we made the statement, my lord. And we also annexed a copy of the application whereby we applied for a certified copy of the order of the Board of Revenue.
So you knew about the date of the order,
Yes.
the number of the appeal.
Now kindly come to the prayer portion, my lord.
Where is that?
Yes. Please come to page 37. 38, my lord. Page 38. As well as order dated 16/9/21 passed by the Assam Board of Revenue in so and so, and first order lodges may deem fit and proper. At page 38. It's a fact we could not annex it because the copy was not handed over. By the time while filing affidavit, they have annexed it, so my lord, we did not. If your lordship thinks that there is some technical flaw, we can always bring on record.
No,
that-
no, not necessary. Already there, it is already there. Pleadings are there. So obviously, the relief does not control the pleadings.
No, my lord, my only humble submission is there is a dispute as to where the industrial unit is located. Now they are backed by two reasons. One, the complaint of respondent number 5, and number 2, at the relevant point of time, only one director was tribal and others were non-tribal. They cannot say anything else because my lord, all permissions were given to us.
No, the fact that you have already admitted there is a sale deed which is already a registered document out there. So the fact that tag number 35 or patta number 30 belongs to the respondent number 5 is not an issue before this court. The only issue is whether your industry is in tag number 95 or patta number 6 or 20, or your industry is in tag number 35 or patta number.
My lord, my humble submission is
There is
this
a
matter
circular-
should be remanded to the Assam Board of Revenue. And Board of Revenue should take a call on this issue. my lord.
Why? We ask them, they come up with a finding, we, on affidavit, we paste it and finish that. The issue is otherwise right if it is 35, because you have to, although you have come up with a question that these are civil disputes which could have been taken
Yes.
into account, and but the fact that there is also a protection which is being mandated
No,
under
look, I'm
150.
relying on a division bench judgment of our High Court. my lord. Please permit me to place that judgment. Daulatram Lakhani, my lord.
That's the full bench judgment.
My lord, 80 is a full bench judgment of our High Court, my lord. 1989, 1 JLR 131.
So, Chaudhary, isn't it the judgment on section 154A,
Yes,
wherein Justice Hansaria has delivered the judgment
On the
to
outskirts of
effect that you
jurisdiction of
cannot
civil
out
court.
the civil court's
yes,
jurisdiction?
yes.
Yeah, that is not the issue out here that they are exercising 154. What we are concerned out here, there is a protection being mandated under the chapter 10 for
Yes.
them. Now, if it is a case of a chapter 10 and there is a infliction of because there are certain protections which is being given. This was given as far back as when the chapter 10 was brought in. But apart from that, there are various other provisions, statutory provisions also, which give certain rights to those SC, ST people for that. So therefore, this court cannot overlook that aspect of the matter. The only issue therefore is whether it is in 95 or 35. 95, you are out. Patents. You are 995.
But there is no adjudication on that.
There is a fine adjudication, clear adjudication by the DC. And that is there. So that, and the circle officer's report is there where there is no independent challenge
No, no, the
specifically to
circle
that.
officer's report had merged in the deceased order.
Circle officer's report could not have merged into deceased order because of the fact that the circle officer's, it was a piece of evidence. Evidence cannot merge with an order. The deceased order will merge with the Board of Revenue's order.
No, that way lordship is perhaps correct. That I am not saying a piece of evidence cannot merge. What can merge is a final opinion. Now question is, my lord, so from the point of view of circle officer, that is also an opinion.
Yes, no, that is a finding.
That question is, my lord, no, where is my lord, let the records be produced, let circle officer satisfy that this opinion was preceded by an exercise. Let them produce the record. Or it was a mechanical thing done on the ipse dixit of the circle officer. The file must reflect that this is an aspect to which the circle officer.
Where is your challenge to that?
My lord,
Where is your challenge to that in your petition? There's nothing mentioned.
technically, yes, but when we challenge the order of deputy commissioner, I think, my lord, that will be included. My lord, in a 226 proceeding, I don't think lordships will, take all these hyper-technical
No,
approach.
I'm not. I won't. Like, just for example, the Board of Revenue order is being not mentioned in the main relief. I'm not into all this hyper-technical. But the fact that you have to have adequate pleadings in respect to the circle officer's report could not have been there.
No, on circle officer's report, we have pleadings. We have
No,
pleadings.
not a
think
single
we have-
pleading to
I
that
just-
effect. You are saying out here that the Board of Revenue as well as the DC has on the basis of just the allegations made by the respondent number 5 has exercised its discretion or the
Lordship will kindly
jurisdiction
give me 1
in
minute
a
time, sir.
ipse dixit manner.
Yes.
The best way, Mr. Chaudhary, is let the deputy commissioner submit a report where your SAYA is there on the
Yes.
basis of the maps,
Let them
battery
furnish-
ends there. Isn't it, Mr. Chaudhary?
No, Malaj.
Really?
May I say something, Malaj?
Yes, yes.
Malaj, the admitted facts are this, that this land falls in a notified tribal belt. That's an admitted part, Malaj. Even in the writ petition, they are saying that this is a notified tribal belt area. So moment it's a notified tribal belt area, Malaj, Chapter 10 applies. And Chapter 10, Malaj, stalls any transfer by any mode. And such transfers are void. Right, Malaj? Now, Malaj, my learned friend's case is a very curious case. He asserts his title, my lords, on DAG number 95. I will place the writ petition, my lords. I will place his pleadings. From DAG number 95, then he says that some part of my land may be overlapping with DAG number 35. Right, my lords? I will place, my lords, the map of that area. Both the lands are on two opposite sides. They are not contiguous land. The circle officer, my lords, conducts an inquiry. He conducts an inquiry and he finds that the industry of my learned friend's client is set up on DAG number 35, which land belongs to, my lord, the respondent number 5. Now that inquiry report, your lordships will find at page 422 to 424 of this writ petition paper book, my lords. Just have that inquiry report. It is not the ipse dixit of the deputy commissioner. This inquiry report is placed before the deputy commissioner. This is not challenged, but just see, my lords, what happens. 422, my lords. Your lordships has that, my lords. This is 28/5/19, my lords, report of the circle officer to the deputy commissioner. With reference to the subject cited above, I would like to bring to your kind notice a case of violation of provisions laid down in Chapter 10 of the Assam Land and Revenue Regulations by an industry in the name of Messrs. Superlight ACC Blocks at Sorutaria, and has also apprised your honor the steps taken up in this regard by the undersigned so far, which is as follows. That Messrs. Superlight Industries is a partnership firm having its office at Kumarpara, Guwahati, so-and-so, and partner by lordships just marked Mukul S. Lamare. And Messrs. Kalyani Promoters Private Limited, represented by its director Naresh Kumar, is set up, please mark this, is set up in DAG number 35 in Patta number 30, covering an area of land measuring 16 bighas, 13 lechas in village Sarutaria under Sonapur Mauja in Sonapur Revenue Circle, the land in which the industry is located falls under South Kamrup Tribal Belt. As learned from the office records and local inquiry, my lords, the said industry was set up in the tribal belt on the strength of one of the partners being the notified class, namely Mukul Lamare. Perusal of the land records revealed that a plot of land measuring 21 bighas and so-and-so kathas lesage was covered by so-and-so, Dag number 95, KP Patta number 20, situated in Revenue Village. The lordships will skip that, come to para 4, my lords. However, some local organizations later complained that Mrs. Mukul S. Lamare does not belong to any of the classes notified under 162 of Chapter 10 of the Assam Land Revenue Regulations, and they prayed to cancel the
Lamare would be a Garu.
Yeah, Lamare is a Khasi Bail. They are in that Meghalaya, the tribe in Meghalaya. It's not a notified tribe, my lords, in Assam. So, my lords,
Lamare would be Khasi.
Khasi.
And Khasi is not a notified
No.
tribe in Islam.
And his tribe certificate has been cancelled, my lord. That's a matter of record. That's why my learned friend said now that we have reconstituted the partnership firm. Now all Rabhas have come in, all 100% Rabhas. Right, my lord? Now please read further, my lord. However, some local...
So therefore, the initial sale which was made
Yes.
to Mr. Lamare was wrong.
Yes. Now what my learned friend is saying is this, my lord. Learned friend claims that they hold the property by virtue of a sale deed. That sale deed was in the name of the partnership firm. Now my learned friend is saying that since Mukul Lamare is out, so we have now brought in Rabhas. So it's a 100% tribal holding partnership firm. But my lord, the sale deed was...
no transfer.
Sorry, my lord?
There is no transfer.
There is no transfer. They are saying that by
Kalyanjit
virtue of the change in constitution of the partnership firm, the partners who have come in are Rabhas, they are notified tribal. So this issue is a non-issue today. That's what they are trying to argue, my lords. That's the additional case set up in the additional affidavit. But my lords, I will point out, my lords, that the sale deed which was executed was with Mukul Lamare, not with this company. Well, let me read further, my lords. It says, however, para 4, some local organizations complain Mukul Lamare does not belong to any of the classes notified in 162 of the Chapter 10 of so-and-so, and they prayed to cancel the mutation. Accordingly, the then circle officer, by following due procedure by order dated 23/3/18 under the provisions of 53A, cancelled the Chitta mutation order of 36/15 of Mr. Mukul Lamare. This order, my lords, your lordships will just mark, is at pages 345, 346. Now, my lords, it is to be noted that the above mentioned Mukul Lamare owned land covered by Dag number 95, and the land over which the industry is located is Dag number 35. As such, both the lands are different, and this clearly implies that Superlight ACC block has no ownership of the land over which the industry is located, and the partner in the meanwhile is no longer a recorded pattadar in any of the land in the said village, as his mutation was already cancelled. That, sir, in the meantime, Kardom Ete, so-and-so, wife of so-and-so, who is the recorded pattadar, covered by Dag number so-and-so, in District Kamrup through her lawful attorney, Ajay Mato, filed a complaint to the undersigned regarding illegal occupation of her above land. But please mark para 7, my lord. Based on the complaint and followed by verification of the same by LM staff of this office, a notice was issued to Surendra Kumar Mittal and others, partners of so-and-so, communicated to asking them to appear before the office of the undersigned, along with the relevant documents relating to the land occupied by the industry and other industries-related documents within 15 days from date of notice. The sir, during the allotted period mentioned in the notice, no one turned up before the undersigned to submit any sort of land documents in proof of ownership by Messrs. Superlight ACC. Instead, in reference to the above notice, a written petition on behalf of the industry was submitted in the office of the undersigned, where the petitioner in this petition submitted that arrangement has been made with the pattedar for procuring the land in question, and also mentioned that the pattedar of the land has given no objection in affidavit by running the unsatisfactory, running the unit factory over her said land, and the petitioner will submit the ownership documents immediately on transfer of the land by industry in favor of the industry. Copy of the petition of affidavit is enclosed. This implies that the authorities of the industry is aware and has accepted the fact that the industry is running into the land owned by Kardam Epe, wife of so-and-so, who is the recorded pattedar of the plot in land number so-and-so, Dag number 35, Patta number 30, situated in revenue. That's how one more opportunity was granted to MS Superlight Industries to appear and produce documents in the office of the undersigned relating to the ownership of the above land by issuing a final notice by order dated so-and-so, 14/9/18, following another 15 days time, unlike the previous time, they neither turned up nor produced any relevant document as was asked to submit. That's why, in spite of according sufficient time to produce documents regarding the ownership of the said land, Messrs. Superlight Industries, the industries of the authorities of the industry failed to produce any document in support of the ownership, and also observed to have turned a deaf ear to the notices served by the. Thus, it is proved Messrs. Superlight has no title to prove ownership over the said land. That, sir, from the above facts, it appears Superlight Industry has been running over the said land by violating the provisions of Chapter 10. Moreover, from the perusal of the partnership deed, the authorities representing the industry do not belong to any of the protected class of persons as per provisions laid down in 162. That implies they are not eligible for ownership of land in South Kamru. And evidently, Section 164 restricts transfer of land by way of sale to any of the members of the other class or the permanent resident of the block. As such, buying of the land by the partners of the industry is not permissible. Hence, as per provisions of Section 165 of so and so, the industry is liable to be evicted. I mean, I pause here for a moment, my lord.
And what is this sale deed agreement for sale is about?
Yes, this agreement for sale is not an agreement for sale. That was, my lords, an affidavit cum no objection certificate, which was taken, my lords, from the respondent number 5. Please have that document, my lords, at page 220. So they know that that factory, my lords, is on the land of the respondent number 5. I, Kardo Mepe, so and so wife of so, I am a citizen of India by birth. I am absolute owner of plot number so and so, bearing so and so, land measuring 11 bigas so and so, dag number 35 is C, 16 bigas. That 221, Superlight has been running the unit factory in my name. I have no objection for running of the unit factory of Mr. Superlight blocks in my land. That I am going to execute lease deed, sale deed with so and so within short time. But no such sale deed was executed. So this is an affidavit cum undertaking which they take, my lords, from the respondent number 5.
In 2018.
Yes, ma'am. And these are vulnerable people, my lords. They are tribals. That's why the protection, my lords. The legislature, my lords, taking note of Article 46 of the Constitution of India, has given this protection. And such protections are prevalent all across the nation, my lords. In Karnataka, in Maharashtra, in Orissa, in Jharkhand, in Assam, in Nagaland. When all the tribal belts are protected, the land transfer is protected, and any such transfer is held to be void. Now, please have the sale, sir, permission. Before that, the sale deed on which my learned friend client claims the right over in this writ petition. This sale deed, my lords, your lordships will see, is at page 164. Starts at 158, my lord. And at every step, my lord, your lordships will see, they are, my lords, improving the case. First, please have the sale deed at page 158. Lordships has that, my lord?
Mr. Chaudhary from Delhi, he is getting the benefits of better lawyers.
No doubt. There is no doubt. They have the benefits of the best legal minds. There is no doubt.
The pyramids of legal
Yes. No doubt, my lord. There is no doubt on that.
By the time this matter goes to Supreme Court, he may have a better suggestion.
No, my lord. One can't have a better legal brain than Mr. Chaudhary. There is no doubt on that. Just have page 158. But Mr. Chaudhary's, my lord's legal skills are also limited to the facts of the case. Just have page 158, my lord.
Yes.
This deed of sale is executed on 3rd September 2010 by Arun Marak, Williamson Sangma, Ranindra Sangma in favor of Kalyani Promoters Private Limited. Right, my lords? Now, please see page 160, my lords. The plot of land is dag number 95. And whereas the above named vendors are the absolute owners in possession of the land of 21 bigas covered by dag number 95. Your lordship says that?
Yes.
The total sale consideration is 17,60,000 minutes. And have the schedule at page 164. Right, my lords?
Yes.
So if we go by this sale deed, my lords, this sale deed itself is hit by chapter 10 because you are transferring it to a entity, my lords, a partnership firm, my lords, which cannot be done because it's ultimately a tribal belt land. Now, what they do, my lords, is the sale permission was in the name of Mukul Lamare.
But Mr. Chaudhary, there is, I remember, a judgment from Rajasthan. The matter went to the Supreme Court wherein it was a society or something to that effect, where in that society it was observed that by lifting the veil, one can very well look into and find out that if these
Who is
were the people belonging to
Yes.
the tribals, because that was also an issue there in the Supreme Court as to whether a transfer can be made to the society or a company. But if it is said that if you can lift the veil and find out that there are members out there who are controlling the affairs of the society or the company, obviously it can be done.
Yes, it can. Now, my lords, just have here, my lords, page 164, my lords, is the scheduled property, my lords, DAG number 95. Now, my lords, what had happened was the sale permission was in the name of Mukul Lamare. So when they noticed this, my lords, objection is raised, my lords, on the registration of the deed in the name of Superlight. So, my lords, the rectification deed is executed at page 172. Just have this. And today, if Mukul Lamare is out, my lord, the land has gone with Mukul Lamare. My learned friend has no title to this land. That is dehosts the fact that his title is to DAG number 95. Just have 172, my lord. This is the rectification deed of 8 February 2015, my lords. The deed, my lords, was of 3rd September 10. The rectification is done because objections were raised. And please come, my lords, to page 175.
So it is now in the name of Mukul Lamare.
Mukul. Now, 175 says that it was wrongly registered in the name of Superlight because it couldn't have been done. The sale permission was in the name of Mukul Lamare, who claimed to be a notified tribal. Now, after this rectification deed, my learned friend's title is not there in any case. Now, he has himself stated that Mukul Lamare is out of the partnership firm. If Mukul Lamare goes, my lord, the land goes with him. And that is dehosts the fact that Mukul Lamare was found, my lord, that his caste is not a notified tribe, my lord, within Assam. So his tribe certificate also has been cancelled.
Where is that?
That your lordships will find in the Deputy Commissioner's report itself. My lord. Just have.
Yes, two.
Oh,
So
your
now that Mukul Lamare is no longer there.
No.
Mr. Chaudhary, Guwahati? No, the Mukul Lamare is not there.
Come to that reconstitution of the deed, Milord, at page number 255. Please come to that deed at page number 257.
Before my learned friend comes to me, just have.
That's wait, Mr.
257, Milord.
250, 254.
It starts at 254, Milord. 255. It's
Here
an
we don't
additional
have-
affidavit filed by us.
No, we don't have 255.
602, my lords. 602, my lords. Running page.
602.
Yes, my lord.
Page number করেছিলাম।
It's part of, my lord, the additional affidavit at page 599.
Please come to Milord, paragraph, page number internal 4.
That's 600.
Now, this agreement witnessed and it is hereby agreed by and between the parties here to follow. It is hereby agreed and declared that.
My learned friend is
retiring
reading page 605, my lords.
60.
It is
60.
hereby agreed and declared that retiring partners have retired or shall be deemed to have retired from partnership business of Superlight ACC block on with effect from 31st day of March 23, leaving the same to be carried on by continuing partner and the incoming partners to the exclusion of the retiring partner on and with effect from 1st day of April of 23. Now, my lord, at internal page number sorry, my lord, at page number 2, and we see Monisha Rabha, Pranav Rabha has come in, Surendra Mittal, Mukul Namare, Rajkamal Saraugi, a winner so-and-so, they have retired.
How do you therefore have the right over the land?
So, my lord, my humble submission is, my lord, the restriction imposed by, my lord, chapter 10, in my humble submission, subject to what our losses may say, is not prohibitory, my lord, it is regulatory. Because power has been given to the government also.
No, let us have everything.
Yes.
The land as per the rectification deed belong to Mukul Lamare.
Lamare.
Once he is out, how do you have that?
Partnership has taken over.
But how there is a transfer to the partnership firm? See, a transfer can happen either by a statute or by way of convenience.
Mukul Lamare is not disputing that this land does not belong to the
No, it
partnership.
cannot, under no circumstances, this owner can have the ownership.
No, my lord.
Whether he disputes or not, that is immaterial.
Initially, when the unit was set up, there was only one tribal director. That's a fact. The others were non-tribal. Then, my lord, in law, they were instructed to do. So they have inducted all the partners who are tribal now.
Everything understood.
Yes.
But how does the firm have the ownership?
Now, the issue is, it is not the case of Mukul Lamare that my land is being encroached upon or illegally possessed by this partnership firm called Superlight AAC. There's no dispute. No, my lord,
But as of
my lord,
now,
my
legally, but
one-
legally
one
speaking, how can there be a transfer
No.
ownership of this?
No, my lord, my one submission, which your lordship did not permit me to complete, as far as the locus of the respondent number 5 in this case, they will have to satisfy your lordships that they're owner of 16 bighas of land. Let them satisfy that.
They
And
have-
I'm sure they are not.
No, they have a sale deed.
My lord, how can there be a sale deed? That's what I'm showing.
No, but you have admitted that in your paragraph number
I
24.
say, my lord, during that operation, some mistake may have occurred. No, question is, my lord, there were 26 bighas of land. Out of 26 bighas, 21 bighas of land was sold to somebody else. So there was 5 bighas of land. How come they have owner of 16 bighas of land? That's what I've shown from the Jamabandi.
Whatever may be. Jamabandi is not a document of title.
At least prima facie, my lord.
Jamabandi or these are mutation records cannot be
It will there, my
documented.
lord. It is in the Jamabandi. It's a record of right.
It is a record of rights.
Yes.
But the fact that there is a sale deed which has not yet been cancelled by any other process.
It
So
is
therefore,
not
our
cancelled.
right is there in dark numbers so and so. So there is no quarrel unless there is a challenge to the sale deed by any person to the effect that he
but-
doesn't have.
Trying to project that this sale deed in respect of DAG number 35 could not have been made in 1989 because this was carved out only in 2004. Therefore, that is a document which is highly disputable and doubtful. How let them show that there existed a DAG number 35 in 1989 when they purportedly made the purchase. The document. They are not.
The authorities categorically say that it is so. What to do?
Question is, that is our whole case is. Assam Board of Revenue has not even applied its mind to this aspect, whether the industry is in DAG number 95 or in 35.
No.
More than
No, Mr. Chaudhary, I think you have not been properly instructed by your account. You see, this is the document. That is why I say, whether patta number 6 originally had DAG number 35. It had. This is the Jamabandi. This is what I am saying.
I have also given the copy of the
That seems to be something very wrong. And then it was struck off of there. This is how it happened. These are also reflect copies.
This, my lord, is at page 331.
Page
331.
331.
Yes.
Yeah. Only see page 77 of their affidavit.
But the 95 was originally number 9. Dug number 9, your lordships will see, my lords. And this has been 35 throughout, my lords. This is our dug.
Page 80.
Page 77. There. So these 6 at that point of time had these dugs, including 35. Yes, I think this page in a running page 331.
77 are we? Page close. Page number is more gundogol here. 77 are right. Can I make one prayer, my lord? Although lordship has devoted a lot of time. My lord, let me reconcile these records, my lord. Immediately on
So you want the dismissal the New Year's?
New Year. Let me reconcile, my lord. There's some
Don't want to.
problem with the page.
Now the question is, you don't want the dismissal in the New Year. So what
I
about
don't
the
want the
marking?
dismissal at the end of the year.
Huh? In fact, yesterday there was a submission being made by a council. Then they don't spoil my Christmas. I said about what about Mark Bill? He says it's just immediately after Mark Bill.
My lord, I am used to playing Rami, my lord. That card. Normally we believe first 2-3 deals you should not win. You should always lose. So in New Year, if you can start with a losing spree, it's not bad. Let me reconcile with this, my lord.
But yeah, whatever may be, I would not, but I would just like to make, I would not like to comment on other aspects.
Yes.
Because whether you have title as regard 95 and all, I don't want to do that. That is not the subject matter of this court.
Yes.
The fact that there is a finding of fact which is clear on the basis of evidence and there's been no challenge to that, your industry is at 35, dark number 35 is the clincher. The opinion which is being given after giving you a hearing also.
And let me take a chance, my lord.
Just in that, I was telling your lordships what their claim is, just I know your lordships is re-notifying the matter. Just have page 12 of the writ petition,
Yes.
Because if Mukul Lamare has gone, the land has gone with Mukul Lamare. The case should end here, Just have page 12 of the writ petition.
But Mr. Chaudhary from Delhi, you are concerned about your client's land.
Yes, yes.
If that is land,
and the industry is on my land.
About 95. It is for the state to do the.
Yes,
state
yes.
is
No,
making-
but the industry is set up on my land. That's the problem.
So therefore, the question is, if it is on 35, which I think so.
Yes, yes. That and the prayer in the writ is on
then in that-
dark number 35.
In that regard, the only recourse is to dismiss the petition here.
Yes. Yes.
If I dismiss the writ here, but the fact that why should this court deal with the
Into dispute.
right, whether they are now. So
These
they
are
have
concurrent
to-
findings, my lord.
Let them
Concurrent
be-
findings of fact of two authorities below, my lord. The lordships in 226 will
So
not
that
act
is
as a
the
superintendent.
only thing, let Mr. Chaudhary from Guwahati have some solace to that effect.
Yes.
Hearing remains in. Then
New Year, my lord. Not on 3rd, any other date.
let this matter be on 7th of January.
Yes, my lord. 7. Grateful, my lord.
Oh, yeah.
The issue was regarding, I was a unit under the erstwhile excise regime and I transitioned myself to GST. Lordship, on the last day, 30th of June 2017, I was availing benefit of notification 20/2007, which provided that whatever amount I pay through PLA, means through challan under excise, I was entitled to self-credit of the same in the next month return. So Lordship, GST came into effect from 1st July 17. The GST law provided that whatever is a closing credit, you can carry it forward under GST regime. And there was a form called Transitional 1, that had to be filed within October 2017. So Lordship, because June was the last month and July we had to file GST returns, I had no scope to carry this amount of self-credit in my returns. So I carried this amount into the Tran 1 form. And second point was, Lordships, that whatever amount that we used to pay in excise regime, it was called like cash payments. There was a ledger called PLA, Permanent Account Ledger, wherein all my cash payments were there. So as of 30th June 17, after setting off my liability for the month of June 17, there was certain excess amount in my PLA, which because of no clarity in the law, what to do about that amount, as a bona fide SSE, we took that amount also in the cash in the Tran 1 form. And we filed this form in 2017, October, when within the due date. But in January 2018, my range superintendent issues me a letter stating that this amount of your transition, you should have filed a refund under the erstwhile regime and you reverse this amount. By this time already I have taken that amount, I have paid a GST, outward supplies tax, by utilizing that credit, because that amount comes in my credit ledger in GST. Though the partial amount was cash, but when whatever I take it through the Tran 1 form, it will hit my credit ledger only in GST, it will not hit my cash ledger. So Lordship, in the proceedings, they issued us a show cause notice. We replied on the grounds that there was no clarity. We are a bona fide SSE, and they also stated in their letters that you take a refund. But why they are disallowing this when there was no revenue implication for the government? Because it was a new regime, Lordship, and it is not that we are a very old unit. There was no disputes with our credits. There was no dispute, okay, that you are not eligible to this amount. Nowhere in the show cause or in the impugned order or at the appellate order also, they have disputed my eligibility. They have only stated because there was no specific provision to carry these two amounts. The provision was to carry the closing balance of Senvet credit. Whether this amount is, and this amount cannot be treated as a Senvet credit, so therefore you are not entitled to take this amount, you file a refund. Our submission, Lordships, during the last day when I argued before our Lordship that revenue neutrality, Lordships, when the department does not dispute my credit, the concept of revenue neutrality is a settled jurisprudence in the erstwhile regime also, Lordship, that if there is no loss to the government exchequer, because they themselves admit in their impugned orders that you are eligible to claim refund of this amount. Since the first day they are paying this, they are on the same plea. And based on that, Lordship, we submitted certain judgment, and Lordship had requested last time to bring certain other judgments also for the purpose of revenue neutrality as to what has the court interpreted. So Lordships, what we had seen during this in the judgments, that all these judgments have traveled from erstwhile Sestet to Lordship Supreme Court. But the Sestet had allowed various appeals on the ground of revenue neutrality. For instance, Lordship, that there was a case like I had imported certain inputs and I was slitting it into pipes and selling it to the customers after paying excise duty. The government department alleged that this process is not amounting to manufacture, and they wanted to recover my Senvet credit. So the Sestet held that when you have already paid the excise duty, so therefore recovery of Senvet credit will not serve purpose. It is a revenue neutral transaction. All these matters went up to the Supreme Court, Lordships, and Supreme Court upheld the jurisprudence of revenue neutrality when there is no loss to the exchequer. Lordship, Bombay High Court in case of Ajinkya Enterprise, Gujarat High Court in case of Creative Enterprises, all these have travelled up to Supreme Court under the erstwhile regime, where the Supreme Court categorically states when it's a revenue neutral situation, there is no loss to the government exchequer.
Show me which one.
Lordships, the first judgment, Lordships, Gujarat High Court, page number 2, Lordships. Page number 1, it starts Creative Enterprise. Page number 2, para number 6, 5 and 6 Lordships. It is necessary to take note of the fact to complete narration of fact that the earlier order of tribunal was challenged by way of tax appeal number this, which came to be till date no step. 6. When one goes to the order of the appellate authority, it is apparent that the respondent has been held to be a manufacturer as defined under 2F. The appellate authority has taken into consideration the activities carried on by the respondent. The tribunal is justified in holding that if the activity of the respondent does not amount to manufacture, there can be no question of levy of duty, and if duty is levied, moderate credit cannot be denied by holding there is no manufacture. In the aforesaid set of facts and circumstances, in case in light of concurrent finding of fact recorded by the tribunal, no question of law, much less a substantial, arises out of the infused order dismissed. Actually, this was carried to Supreme Court in page number 3. Wherein the department SLP was dismissed as it was reported. On the ground of revenue neutrality, because when I have paid the excise duty, my senvet cannot be denied to me, Lordships. Next, Lordships, is that there is a judgment in page number 6, Lordships, there is Sestet Bombay, which was affirmed by the Honorable Supreme Court in page number 11. Paragraph number, Lordships. Lordship, para number 5, page number 10. Penultimate paragraph. May I please?
Yes.
In view of the above judgment, it has been consistently held that even though duty is payable and the recipient unit is a part of the same entity and is eligible for moderate senvet credit paying duty from PLA also, then it is a revenue neutral exercise. For this reason, demand of duty cannot be recovered. Following the ratio of the above referred judgment, we are of the view that the duty of demand is not sustainable, being a revenue neutral situation. Since we decide the appeal on revenue neutrality, we are not visiting the issue of valuation. Now, Lordship, this was carried to the Supreme Court at page number 11. The Supreme Court record, Lordship, delay condoned heard the learned counsel for the appellant. Having pursued the order of the sested, we are of the view that the finding on point of revenue neutrality has been correctly arrived at by the learned tribunal. We therefore do not entertain the present appeal. The appeal is dismissed. And Lordship, page number 12 is the appeal of the judgment of the Supreme Court, wherein the issue was as regards when I have paid a duty at a higher rate and my customer has taken the input credit of that duty, whether the customer can be denied that senvet credit. The Supreme Court held no. If the duty payment is not disputed, it's a revenue neutral exercise because it is moderatable. Suppose instead of 10%, I had paid 12% at the time of clearance. Then the input to the customer cannot be denied. The appeal of the revenue was dismissed in this case. As to whether by overvaluing the goods or by overcharging the amounts, whether if credit has been passed on, whether that can be recovered from the customer, the answer was no. Page 14 was a Bombay Tribunal judgment in case of Jet Airways, which was carried to Supreme Court and it was affirmed. Here, Lordship, the question was whether on certain import of services, if I have not paid service tax under reverse charge, and if I would have paid, I would have availed senvet credit also. There was no dispute with the fact. The tribunal deleted the entire demand on the question of revenue neutrality. It was carried up to Supreme Court at page 19, Lordships, and the Supreme Court has affirmed the order of the tribunal and the appeal of the revenue was dismissed. These are all appeals under Statutory Appeal 35G, Lordships.
25 page.
25. Para number 8. Para number 5, it records the revenue neutrality. That same lordship, whether if the activity does not tend amount to manufacture, but if the duty is being paid, can the SENVET be recovered?
You know, the paragraph 8.
Paragraph 8.
That paragraph gives a more clear instructions. So your case is therefore there was certain amount which came in your PL account.
2 amounts, lordship. One in the PLA amount closing and one the self credit of 20 by 2007. After every month, lordship, as per 20 by 2007, whatever amount is paid as challan for that month, excise duty, I am entitled to take that as credit in the next month. So June 2017 was the last excise return. In that, I paid 16 lakh odd rupees through challan for excise duty. So that amount was to be taken as self credit by me. So that, because July there was no excise return and that notification has not been done away with, that notification has become redundant. So where to take that amount? In excise return, lordship, there's a table of SENVET. I have attached that excise return also in the petition. That is at lordship page number.
Where do they say that there is a refundable amount?
Lordships, they start their first letter, lordships, kindly takes it at page 43. The first letter which they initiated the proceedings.
Yes.
Annexure 3, lordship, may I please?
Yes.
Dear sir, it is to inform that you have GST and availed rupees this under transitional provision of section 140. It has been informed that you have taken the PLA closing balance and self credit amounting to rupees this as transitional credit, but CGST Act does not have any provision regarding carry forward of PLA into transitional credit. However, the same may be claimed as refund as per 11B of the Excise Act. You are requested to reverse the same. They themselves admit in the first proceedings. To this lordship, we file a reply at page 44 to this letter. We give our basis as to what is our basis because there is no clarity in the law. And October being the last date, I had to take this amount.
Then
Lordship, then they issue a show cause at page 56.
what are these FAQs?
Lordship, these are general correspondences that they have given with their letters. Page 56 is the SCA. Lordship, para 2 of the SCA, may I please? The superintendent of CGST range on the basis of study of Tran 1 for taking transitional credit under 140 found that the SSD had taken a total credit of rupees 38,84,435 as Tran 1 credit. Out of the above mentioned amount, the amount of SENVET credit carried forward to the credit ledger as central tax under 140 subsection 1 and section 140 subsection 4 clause A and 140 subsection 9 under table 5A of the Tran 1 is 33,69,271. It is further noticed that the above mentioned rupees 33,69,271 is nothing but the self credit plus
What
closing
happened,
balance.
you see, every time you file your returns,
Lordship.
every month,
Lordship.
as per that
old 20 by 2007.
To file your returns. Once you file your returns, there's an order passed.
No, Lordship. Excise was a self-assessment. Excise was a self-assessment.
So if you are there in the industrial policy,
I was there in the industrial policy. Order would be passed in case if I go for a special rate fixation. There are two modes, Lordships. One is whatever the rate as defined in the schedule to the notification, industry average rate. I am taking benefit of that. If I want a special rate, the notification provides that if the rate which is given in the schedule, as per you, if the value addition is higher, then you have to apply basis CS certificate that you want a special rate. Then in that case, whatever amount is after I file a special rate application, if that is allowed, then I get an enhanced rate. Otherwise, whatever I have as per the policy, I will get that. Therefore, it was self-credit, Lordships. And therefore, they acknowledged it's a self-credit every month.
where will I find that in that?
20 by 2007, Lordship, I have attached that notification. That is at page number 31, Lordships. Lordships. In exercise of the powers conferred under Section 5A of the Central Excise Act, the government being satisfied it is necessary in the public interest exempts the goods specified in the first schedule to the Central Excise tariff other than those mentioned in the annexure and cleared from a unit located in Assam, Tripura, Meghalaya, Mizoram, Manipur, Nagaland, Arunachal or Sikkim, as the case may be, from so much of the duty of excise level thereon under said act as is equivalent to the amount of duty paid by the manufacturer of goods other than the amount of duty paid by utilization of Senvet credit under the Senvet credit rules. That means, Lordships, if my duty is 100 rupees, my cash payment is 60 rupees and my Senvet is 40 rupees. So I'm exempted by 60 rupees other than the Senvet. In case where all goods manufactured by a manufacturer are eligible for exemption under the notification, the exemption contained in them shall be available subject to the condition that the manufacturer first utilizes whole of Senvet credit available to him on the last day of the month under consideration for payment of duty of goods cleared during such month and pays only the balance amount in cash. They are again clarifying that only the cash amount which you pay as excise duty will be given to you, because it is a case where first you have to pay and then take. It is not a direct exemption, Lordships. The exemption contained in the notification shall be given in the following manner. The manufacturer shall submit a statement of duty paid other than the amount to be paid, other than the amount of duty paid by utilization of Senvet credit to the assistant commissioner or the deputy commissioner as the case may be by 7th of the next month in which the duty has been paid other than the amount paid by utilization of Senvet credit. The assistant commissioner, as the case may be after such verification as may be deemed necessary, shall refund the amount of duty paid other than the amount of duty paid by utilization of Senvet credit during the month under consideration by 15th of the
This is what, Mr. Karundi, I was asking you.
Lordship, it was through excise returns. I will show that excise returns has this table. Every month, Lordship, excise return has to be filed by 10th of the next month. So in that return, they have prepared a table which is an application. There is no separate application.
7th, not 10th. 7th.
Lordship, they were earlier it was 7 because it's 2007. Later on, the excise return due date was increased up to 10th of the next.
But as we read, it is 7th.
7th, Lordship, because it was 2007 that time. Our period is
Then
7.
you will be only given a refund as regards the amount which you have paid in cash.
Only cash. And that is what is it is the self-credit, Lordship. Because every month.
So therefore, there is a verification procedure which is being carried out.
Correct, Lordship. So in my case today, Lordship, they don't doubt that. Because the excise return, whenever we file excise return, we give a remarks. There's a column of remarks that, okay, this amount will be taken as self-credit in the next month. If they have any doubts, they will issue a notice. Okay, you are not eligible. You share your Senvet register.
Let us see the further procedure.
Lordship,
how
Lordship,
how
I
it
place.
will be used by self-credit.
Provided that in cases where the exemption contained in the notification is not applicable to some of the goods produced by a manufacturer, such refund shall not exceed the amount of duty paid less the amount of Senvet availed of in respect of duty paid on the inputs used in or in relation to the manufacture of goods cleared under this notification. If there is likely to be any delay in the verification, assistant commissioner or the deputy commissioner as the case may be shall refund the amount on provisional basis by 15th of the next month to the month under consideration and thereafter may adjust the amount of refund by such amount as may be necessary and subsequent refunds admissible to the manufacturer.
So there also presupposes a passing of an order.
Lordships, because 2007 when it was there was offline mechanism. ER1, all these online returns came into picture with the generation of ACES, which was in 2012. Lordships. Notwithstanding anything contained in para 3, the manufacturer at his own option may take credit of the amount of duty paid during the month under consideration, other than by way of utilization of Senvet credit under the Senvet credit rules in his account current maintained in terms of Part 5 of the Excise Manual of Supplementary Instruction issued by CBIC. Such amount credited to the account current may be utilized by the manufacturer for payment of duty in a manner specified in Rule 8 in subsequent months, and such payment should be deemed to be payment in cash. I stop.
This is the basis.
This is the basis, self-credit. So, Lordship, the important to note here is that the amount is to be taken in account current. Account current means the PLA, Lordship, not the credit ledger. So, whatever amount I pay through PLA in the previous month, I take that amount in my account current in the subsequent month. I cannot take that as a Senvet credit. This is again to be taken in account current to be utilized in next month's excise duty liability. That will be clear from the ER1 return, Lordship, which is I have placed. May I place this further?
To me, where?
ER1, Lordships. Page 35, Lordships. Page 35 is the abstract, Lordship. Page 36, last table. There is an abstract of account current. Heading is extract of account current, Lordship. Lordship is there. Lordship, it says opening balance.
Yes.
So this is my balance as on first day of that month. This is my cash balance, which I am, Lordship, what happens generally in excise units, they keep certain amount in cash ledger. For suppose if there's any demand or for any recovery measure, so we can say interest will not be liable because we have already paid certain amount. So there's a practice with the industry that to keep certain amounts in the cash ledger. This is the opening balance as of the first day. Next, Lordship, GAR 7 challan paid in the month. That is my deposits through challan for the month of June.
Cash payment.
Cash payment. Total amount available after adding opening, this cash payment, 33.
So this 10 lakhs which is there,
Sir, Lordship.
this is an amount which has nothing to do with the Senvet payment.
Nothing. This is totally cash.
This you just keep it.
We keep it for any future demands or anything.
There would not be any interest.
Interest like that. I go down. Then, Lordship, total amount available comes 33. Then that is most important under the forward payment of duties on excisable goods during the month. This amount is that amount which I pay for the month of June through cash. How I can prove this, Lordships? Kindly takes the table just above it. Details of duty paid on excisable goods. Just above. Total duty, last column, Lordship, is 35 lakhs. So my total liability for June was 35 lakhs. So the notification says that first you have to exhaust your Senvet credit. That is at page 37, Lordships. Kindly takes page 37.
So this 1,65,000,
16,50,000
is at serial number 4.
is at serial number 4.
The account come rent.
Account current, Lordship. You know, it is, Lordship, typed copy it is actually.
Account current.
Account current, PLA ledger.
So this is the account current.
Yes, Lordship. Credit amount is just before that. What is the amount of Senvet credit?
Credit. This is 18 lakhs is the
Is the Senvet credit.
Senvet. The other one is account.
PLA, cash.
So here you pay this and that the amount comes to 35.
So total amount comes to 35 lakh, which is my duty payable for the month of June.
So here you take 1,65,000 is being
16 lakh 50,000 is being used for the through cash for the month of June.
16 lakhs which is being shown out here.
Lordships.
And then this is being shown and then the amount available. Why does it become less? 17 lakhs means it is
Lordship,
subtracted
because out
from
of 33 lakhs, my opening plus my during the month payment, less 16 lakhs which I utilize. So my closing balance is 17 lakhs.
Oh, so from here you use 16 lakhs.
Here, yes, from 33 I use 16.
16. And then it comes to 17 lakhs.
So, Lordship, the dispute before your office to this honorable court is 17 lakhs, which is the closing balance of PLA, and this 1650, which is the self credit. These two amounts are disputed.
These two are the amounts.
These two are the amounts which the department says you should have claimed a refund under the erstwhile regime. You should not have carried forward under same. And Lordship kindly takes the remarks in page number 38, Lordship, the last page of the return. Here, this 2271 that I shown you, Lordship, in page number 36, that was during the month payment. That was last month's self-credit.
But this is for June.
This is for the month of June. So
May.
in the month of June, I will take the self-credit of May. So 2271 was the self-credit of May, which I took in June in the account current, which notification 20/2007 states that you take that amount in your account current in the subsequent month to be taken as GAR7 challan payments.
Okay, then
So Lordship, the dispute in this matter is the self-credit of 1650, which is the amount which I pay through PLA for the month of June, and my closing balance of 17 lakhs, which is standing in my PLA balance, in my returns as closing balance of PLA on 30th June. My predicament that July GST came in. Had excise been there, I would have taken the self-credit in ER1. The 1650 would have been shown instead of 2271 for the month of July. Suppose, Lordship, there would have been a July excise also. Then instead of this 2271, the self-credit, this amount would be 1650. 1650 is the amount which is the self-credit to be taken by me for the month of June. I would have taken that in the account current, and accordingly my PLA balance would have been up and down. Department says you are entitled to refund of this amount. You file a refund application, but you have done a crime by taking this under GST.
let us first see from page 32 how it is done. Page 32.
Page 32.
I did that where
Provided, now through the notification, Lordship, from the provision. Provided that where the exemption contained in this notification is not applicable to some of the goods produced by a manufacturer, the amount of such credit shall not exceed the amount of duty paid less the amount of senbet availed in respect of duty paid on inputs used in or in relation to manufacture of the goods cleared under the notification. That says that if I am manufacturing two products, one is not covered under exemption, I will get pro rata benefit, not applicable in my case. Clause B, the credit of the duty paid during the month under consideration, other than by way of utilization of senbet credit under the senbet credit rules, may be taken by the manufacturer in his account credit by the 7th day of the month following the month under consideration.
that is for May, June.
May, June. C, a manufacturer who intends to avail the option under clause A shall exercise an option in writing for availing such option before effecting the first clearance in any financial year, and such option shall be effective from the date of exercise of the option and shall not be withdrawn during the remaining part of the financial year. Provided that financial year 7-8, the manufacturer shall exercise his option before or 31st May 7. Clause D, the manufacturer shall submit a statement of duty paid other than by way of utilization of credit under the CCR 2004, along with the refund amount which he has taken credit and the calculation particulars of such credit to the Assistant Commissioner, as the case may be, by 7th day of the next month to the month under consideration. Earlier, Lordship, because it was manual excise returns. These statements, these returns were in hard copies. So that is why it says you have to submit. Once SS came into picture from 2012, everything was online.
And
So, may I
but
please?
this notification does not take into consideration the amendments which have been made subsequent to 2012.
No, Lordship. 2012, Lordship, just the portal came. There was a portal like today we have a GST portal. Similarly, in Excise in 2012, there was a pilot project of the central government called ACES.
But does it therefore not require the very, this is okay. By 4, you can now take a senbet credit, the credit
In the account current.
in the account card
Lordship.
you can take. So this was brought in. This was
2007 only.
there. Now, So therefore, the verification is not required.
Verification, if lordship, I submit my online return. Now, I will take that amount of self-credit in the next month. Department has time till 30 days. Every month when they see my return, if they want to scrutinize, if they want any documents, they can ask me because it is self-assessment now. That time it became self-assessment. Excise was under self-assessment lotships. So if they have any issues, they will ask me in writing. I will produce my signed register. I will produce the invoice copies.
And if they can't do it by 15th, they will pass a provisional order.
They will pass a provision.
But now the requirement of passing a provisional order or the final order still remains.
No, lordship, it does not remain. Lordship, kindly takes clause 4 again. It says notwithstanding anything contained in 3. So 3 was wherein the option is not of self-credit. 4 is notwithstanding 3. Means if I take on self-credit basis, this is the mechanism I can take myself. Now department.
No, very well.
Lordships.
4 is pertaining to self-credit.
Lordships.
3 is an obligation cast upon the department to come up with a provisional order or a final order by 15th.
Lordships.
So this is a benefit which is now being given to 4, gives a benefit to the SSC.
Lordships.
But does it absorb the duty of the department in respect to 3?
No, lordship. I most humbly know. They are they should. They are bound, in fact,
So
to
therefore,
do a verification.
Therefore, they are bound in the 3.
Correct,
But
lordship.
4 is only for the benefit
Beneficial
of
provision
the
to the
SSC.
so that the day-to-day activities are not hampered.
So you can very well take unnecessary. You need not wait
Lordships,
for all these
lordships,
things.
I would have.
So therefore, 4 is a beneficial to you,
Lordships.
but that does not absolve the
Department to conduct any scrutiny.
not only the scrutiny to also pass
Pass an
the
order.
order.
Pass an order if they find something, and they have to pass an order. In fact, going by the terminology used in paragraph.
So has the department passed that order in
No,
terms of?
no, lordship. Nothing.
So
in
they
hand.
did not.
Nothing. Yeah, and because lordship, the show
Because that is a relevant aspect.
I got
While,
it. I got
while
it.
you are taking up, because on one hand you are not, you admit to that you are entitled to the refund of the amount, but you are not giving them the
Lordship.
Then on the basis thereof, you go into the question of revenue
Lordship,
neutrality.
that is why I started with the thing, lordship. There is no dispute as to my eligibility. And lordship, there are judgments to that effect that if the department has accepted my returns under self-assessment and there is no scrutiny or any objection, then future any litigation on that cannot arise. Lordship, in fact, the Supreme Court in ITC Limited, it ruled in favor of the department that in customs, it is self-assessment. When it is self-assessment, I cannot, if I have suppose paid an excise duty and I want to claim a refund, if I don't challenge that assessment myself, means my return I should challenge by way of an appeal to the department, then I will not be allowed to take a refund unless I challenge my own self-assessment.
Now kindly come to E.
Lordships. The Assistant Commissioner of Central Excise or the Deputy Commissioner of Excise, as the case may be, after such verification as may be deemed necessary, shall determine the amount correctly refundable to the manufacturer and intimate the same to the manufacturer by 15th of the next month to the month under consideration. In case the credit taken by manufacturer is in excess of the amount determined, the manufacturer shall within 5 days from the receipt of the intimation reverse the said excess credit from the said account current maintained by him. In case the credit may be taken by manufacturer is less, then the amount of refund determined, the manufacturer shall be eligible to take the credit of balance.
So this is the thing which they are required to do.
They are required, but in my case, they have admitted that it is a eligible credit.
Understood. So
Gotcha.
they have, by way of that asking, they have not performed in terms with this. But they have said that you are to make, if they did it in terms with your return filed on 3110.
Lordships. They said that, Lordship, it's a proceeding under CGST Act, not a proceeding under Excise Act.
So here they did not do this.
They did not do this, and they admitted to the fact that, okay, this amount was eligible to you under the erstwhile regime. However, carrying forward in GST regime, we have problems.
Now, tell me, what does the CGST say in respect to those industrial policies which were in operation as regards excise duty being given? What does the CGST say on this?
Lordship, CGST Act does not have any particular provisions. But Lordship, all these industrial policies, which will be continued by in the northeastern states in Himachal Pradesh also, had been continued by central government. Because Lordship, there were two kinds of policies. In some states, the state government was also giving some incentive and subsidies. So that state government's policies were on different footing. But central excise, when this GST came into picture, all these benefits, like suppose Lordship, in GST, what has happened for northeastern states, if I am eligible for the period, then in GST there are two, one is CGST, one is SGST. So now they are giving me a percentage of CGST. They are reimbursing me the amount which I pay through the cash ledger of CGST. So the policy is being continued till the period I am entitled to it. Say a policy was for a period of 10 years. I started my industrial unit in 2012. So it would have ended in 2022. 17 GST came. So first year it was a problem. Then there were notifications to that extent which stated, okay, we will give you this amount but under CGST. Because state stated, Lordship, when GST what happens, entire thing goes to the council. Council is the supreme authority under 246A, wherein decision of council is binding on all. So,
Is it?
Lordship, in VVF it has been, your Lordships have also taken that into account in that 168-day judgment. Lordship, I am not into that controversy still. Lordship, so various states stated, we will not give our share. We will come up with our policy. If we want.
Understood.
Lordship.
Therefore, why I'm saying is this. You see, it's an industrial policy.
Lordship.
Get the benefit under the industrial policy because of the whatever thing is as well as a promise being given.
Lordship.
Now, this promise can be very well taken over by a statute.
By a statute. Lordship. That is settled by Supreme Court.
Promissory estoppel against a statute.
Lordship. Lordship.
Therefore, my question was to you that does it negate your rights by way of the CGST Act?
No, Lordship, no. Why, Lordship? And I'll again just stress one point. Had suppose, Lordship, this dispute before your Lordship would be for the month of July. If I would have come to your Lordship, that in the month of July, I have paid this amount through Challan, and my eligibility under the old policy should continue up to 2020, and the government is not reimbursing me, then that point would have been into picture whether that policy of the erstwhile regime, whether the government brings a notification to bring a stop date to the policy, even though the period is lapsed, even if the period is pending, government can bring a statute by saying, okay, this policy will end on this day. That is what Unicorn Industries, Honorable Supreme Court Justice Mishra's judgment was there. How that it is not a promissory estoppel will not lay. So the current case before your Lordships is for the month of June. So there is no dispute as to the applicability of policy to me.
No. Therefore, my
Lordship.
question is, so this exercise, which was supposed to be done under 4E,
Lordship.
3 is 1,
4E.
4E also.
Lordships.
Was it done?
Lordship, no. No, it was not done. We don't have any document to say that, okay, my verification they have conducted. In fact,
Or have they informed you?
No,
That,
Lordship,
look
nothing.
here, you could not have taken this.
Nothing. They informed me through my Tran 1. Once I filed the Tran 1, Tran 1 has taken this amount. They verified my Tran 1 because in Tran 1 there are various tables as to what amounts you are taking. So on verification of Tran 1, they issued me a notice that, okay, this amount of 17 and 16 which you are taking, there is no specific provision under GST law, you claim a refund. That was the basis of the show cause, Lordships. I'll again take your.
In case the manufacturer fails to comply with A to E, shall forfeit the option to take credit. So all these A to E.
All these.
So,
Then Lordship, it is like if after scrutiny,
or availed in excess determined.
that means
Can
if
you
that
see
is
G?
I will.
Very relevant.
The amount of credit availed irregularly or availed in excess of the amount determined correctly refundable under clause EL not reversed by the manufacturer within the period specified in that
No,
clause
the word important is determined.
determined by the department.
So therefore, there has to be a determination
Determination.
that there has been in excess or so.
Lordships. They have to carry out an exercise for verification.
If the duty
Specified
of
in
the-
this clause shall be recoverable as if it is a recovery of excise duty erroneously refunded. In case such irregular excess credit is utilized for payment of excise duty on clearance of excisable goods, the said goods should be considered to have been cleared without payment of duty to the extent of utilization of such irregular excess.
So this has also not been done.
Nothing.
So therefore, your question is in view of this being not done, and there being no embargo under the CGST Act,
There being no specific provision, Lordship, for me as to whether this cannot be carried.
there being no, that is, one is not specific provision is not there, is another aspect.
Lordships.
But is there is a prohibition?
No, Lordship, no prohibition.
So that is the question.
No,
If
no
there
prohibition.
is no prohibition out there, why should you not be
Allowed to
entitled?
that. And to that extent, Lordship, when the department itself says you are entitled to a refund, secondary, when they themselves admit to the fact, and in all the orders also in the impugned OIO as well as the order in appeal, it has not been disputed that this amount is not refundable to the assessor.
So the only question which remains out here after all these things is whether the CGST Act debars you from taking.
Yes, Lordship.
If there is no bar, then why you would not be entitled?
Lordship, in that case, section 140 subsection 1 of the CGST Act, which is the master section for carrying forward transitional provisions, they define, they say, it says that closing balance of send-back credit. It says closing balance of send-back credit can be taken.
Yes, anybody has a send on CGST?
I'm giving my copy. Lordships.
So the issue is the fact that are these provisions overridden by any of the provisions?
And revenue neutrality. And revenue neutrality.
Revenue neutrality will come
Lordship.
later on.
Lordship.
But the first is whether it is overridden.
Lordship.
If it is overridden, then you are hit again by promissory stop. I mean, therefore, I'm saying,
Lordship.
if it is not, then you are entitled to.
And Lordship,
And
section
once
140
you are entitled to, why should we go into the question of revenue
Lordship,
neutrality?
Lordship, I bowed out.
Yes.
Section 140. Transitional arrangement for ITC. A registered, subsection 1. A registered person other than a person opting to pay tax under section 10. Section 10 is Lordship composition scheme under GST. Shall be entitled to take in his electronic credit ledger the amount of send-back credit of eligible duties carried forward in the return relating to the period ending with the day immediately preceding the appointed day, furnished by him under the existing law within such time and such manner as may be prescribed, provided that the registered person shall not be allowed to take the credit in the following circumstances, namely, where the said amount of credit is not admissible as ITC under this Act, where he has not furnished all the returns required under the existing law for the period of 6 months immediately preceding the appointed day, or where the amount of credit relates to goods manufactured and cleared under such exemption as are notified by the government.
Where the said amount of credit
Relates to goods
So
manufactured.
therefore, those send back credit, because you are not entitled to the benefit of taking back.
That
As
was
per,
not send-back credit, that was electronic. Lordship.
as per the notification of 20,
Lordship.
you are not entitled to the refund of the send back credit.
I'm not entitled.
So therefore, if you read 41.3,
Lordship.
you see 41 is only in respect to send back credit.
Only send-back credit.
And where's the said amount of credit relates to goods manufactured and cleared under such exemption as are notified by the
So
government.
it is not my case at all.
Therefore, it is not your case
Lordship.
to that effect.
Lordship.
So because you are otherwise also not
Debarred to
entitled
take
to the
send-back.
send back.
Great. I go down. Then Lordship, then subsection 2 and everything are other forms, like if I have unavailed credit, if I was under composition scheme under erstwhile regime and new regime.
A rate under other than AR thing to pay under section 10. We are nothing to do with
Nothing.
section.
Lordship, now come importance explanation, which defines send-back credit, which is at explanation 1, Lordships. For the purpose of subsection 1, the expression eligible duties means,
Unable send back credit.
Lordships,
Explanation?
the explanation 1,
Where is explanation?
Lord, after subsection 10.
Oh, subsection 10.
This is explanation to section 140. Lordships. For the purpose of subsection 1, the expression eligible duties means additional duty of excise, additional duty under various acts. The duty, clause number 6 is the duty of excise specified in second schedule to central excise tax, which is the excise duty. Which is the excise duty. Then Lordship, again, explanation 2. For the purpose of subsection 1, eligible duties and taxes means additional duty, clause number 5, the duty of excise specified in first schedule of the central excise tax.
What is
So-
the difference between first and
Lordship,
second?
The MRP based certain products were under third schedule, certain products were in a second, and basically all the products were in the first schedule of the central excise tax. And clause 8 of explanation 2 also takes into account service tax. So my case is not of service.
So there is no bar.
On the reading of this, Lordship, there is no bar. Because Lordship, 140 subsection 1 says amount of Senvet credit of eligible duties and tax carried forward. So eligible duties, they have defined eligible duties and taxes and eligible duties separately.
Shall be entitled to take in each electronic credit the amount of other than shall be entitled to the eligible duties.
Eligible duties, Lordship, it was replaced. Earlier, it was,
So as per for 141, why you are saying that this would not include this?
Lordship, they are saying,
They are saying
that Senvet credit has been, Senvet credit was used. So PLA amount and your self credit is not a Senvet credit.
maybe.
This is
But,
what,
but is it number 2 is, oh, this was brought in 2018
Lordship, after through a retrospective amendment.
with effect from retrospective. So now, why you are not entitled then?
Lordship, my case is I am entitled.
No, understood.
Lordship,
So why the department now says, after the amendment which has been made with effect from 1/7/2007 to include of eligible duties,
Lordship. So eligible duties now they have defined in the explanation 2,
explanation 1.
explanation 1.
Yes.
In that,
So it will include additional duty and
clause number 5 is
duty of
important for
excise.
us, Lordship. Duty of excise under first schedule.
First and the second schedule.
First and the second schedule both. My case is not of MRP, so I am not covered into that.
So you come under first.
I come under first.
So 5.
5.
So if it is a case of 5 and
Well,
it has
Lordship,
been
that is to
brought
be
into
read
a-
with in respect of inputs held in stock and inputs contained in semi-finished goods held in stock on the appointed day. So their saying is that this should be a Senvet credit of your closing stock.
Yeah, the amount of Senvet credit of eligible duties
Of eligible duties.
carried forward. So this is only for Senvet
For
credit.
me, subsection 140, subsection 1,
It's only for Senvet credit.
Senvet credit of excise duty.
So which you are not concerned.
I am not concerned with the
141.
140 subsection 1, Senvet credit of eligible duty. I am only on this.
So you are not there because you don't get the benefit of the central excise on the central excise Senvet credit.
Senvet credit,
Refund.
I am not carrying forward Senvet credit at all. I am carrying forward the self credit and the PLA balance.
But self credit is not there in 141.
Notice 141 says excise duty as levied. Senvet credit of eligible duty. Senvet credit of eligible duties. Eligible duty is excise duty. Clause number 5 of explanation 1.
Yeah.
So I interpret this as Senvet credit of excise duty. My excise duty, which I had paid on clearance of finished products under 20/2007 through PLA, is a Senvet credit fund as per 20/2007.
But you may not be entitled. Are you entitled to the Senvet credit?
Senvet credit, I am not taking the Senvet credit because I am debarred under 20/2007. Your Lordship has seen that. That 16,50,000, it was arrived after deducting the Senvet credit. But what does the notification says? That amount that you pay through challan will be taken. That's an output duty. It's a excise duty amount. That excise duty you have to take as account in your account current. So in the next month, had there been an excise return, it comes in account current. Because there is no excise return, it comes through turn one through send-back credit of eligible duty.
That will be a send-back credit of eligible duty.
Lordship, eligible duty includes excise duty. Lordship, two portions. One is the self-credit, other is the closing balance of PLA. Closing balance of PLA, there may be a case that it is not a duty at all, it is just a deposit. Department, what is that? What is their pleading? I am telling the Lordship. They state it is a closing balance is in the nature of deposit. So it is not a duty. So we will not allow you. You claim a refund. And for send-back credit, for this self-credit, they say the same point, that it is not send-back credit. Wherein as I say, it is send-back credit of eligible duty. As per the scheme of 20/2007, it was to be taken as self-credit. And it is of excise duty only, because my output is of excise duty.
Again, here you see, you are
Lordship.
not entitled to what?
Send-back credit.
Send-back credit.
Send-back credit, Lordship,
If I submit an amount so and so utilization amount by the next which the duty has been paid a year, other than the amount of duty paid by utilization of send-back
So, Lordship,
credit.
a manufacturer, my say output is 100 rupees, excise duty. I utilize raw materials on which I pay excise duty. I utilize services on which I pay service tax. My input, raw material and my services are combinedly called send-back credit. 100 rupees is my output, say my input of raw material and service is 40. So send-back credit is 40. 100 minus 40, 60 is what I pay through challan. As per 20/2007 clause 4, I can take that as self-credit.
60.
60.
It is send-back,
Credit of excise duty. That is excise duty amount. But-
send-back of excise duty.
Send-back of eligible duty, excise duty.
Send-back credit of excise duty.
Lordships. So I place, for me, because there was no excise return and it had to be taken as a self-credit, it becomes send-back credit of eligible duty. Eligible duty, as per explanation 1, includes excise duty. Under clause 5. And the second amount of PLA, Lordships, it was by deposit. They say you file a refund. As a bona fide SSC, because there was no clarity in the law. First time GST came in 2017 July. The target date to file this return was 31st October. As a bona fide SSC, we took that amount and we paid duty to the government. Output duty. We have not taken any refund and anything. We have paid output duty to the government.
So now your 33 lakh
Lordship,
is still lying there.
I have already paid. I have utilized that amount for my clearances in GST.
So you have cleared it.
I have cleared it.
So therefore you have used it.
I have used it.
Now they say that you are not entitled to that to use it. So therefore you are
To reverse this amount and claim a refund under that law.
that law and take this particular and again pay this amount.
You first pay here and then take a refund under this.
Along with interest and penalty.
Interest and penalty now, Lordship. In fact, government has proposed a scheme which has been floated that first 3 years of GST, all cases of 73, interest penalty waived off.
But this is the recent.
Lordship, section 128A has been introduced from 1st November.
Those who file the return or those who don't file a petition, however.
Lordship, writ petition has to be withdrawn. Of course, I am not, Lordship, I am not on that point at all. Because your Lordship's first order had asked me to deposit 100%. That is already deposited.
No, that's why I didn't take the reason why.
Lordships.
Hey, when I used to do a taxation matters, more particularly the entry tax matters.
Lordships.
Initially, our High Court had set up that it held it. Then they came up with another amendment. And thereby they gave a status amendment whereby that amendment was again challenged and this court upheld it. Matter went to the Supreme to have the Jindal Steels 5 judges. 5 judges. Gujarat High Court was the first judgment which came, which decided end to the all.
Yes, yes, Lordships.
Before this matter went out there. Then after the matter went out there to 9 judges, and 9 judges the tax on service. Everything is gone. Now these people who have who were the assessors out there who did not pay, they were really heartbroken because they didn't obviously collect anymore. Can't help it now. That is the law. They have to pay. Now the plight of the means yes, in some cases where the industry out there is not in a position, we can very well take it. It's but otherwise the question of penalty and interest becomes so much at the end of the day. So therefore, they will always take control that whoever
That
has
is what
to
has
pay,
happened
pay.
in this royalty judgment by the Supreme Court, 9 member bench, whether royalty is a tax or not in mineral development. Now they have held royalty to be a tax. Now, mineral development, whether royalty was not paid by many SSEs, that is, they have given an installment up to 24 years. But now the second issue, which is again pending before Supreme Court, is whether GST or service tax is payable on that royalty in the case of Udaipur chambers, which is running in the list. So every day, and these matters at Jharkhand and other states, lordship, which are mining oriented states, the stakes are in X crores. And today people, governments are issuing advisory. Okay, after mineral development, when it has been held, royalty is not a tax. You at least pay under first 3 years, you get a benefit of interest and penalty waiver. All the state departments are issuing advisories to the SSEs to come up under this scheme and pay voluntary. And in fact, government brought up a very good circular in GST, lordship. They say, okay, if because it was reverse charge, today if you pay that amount, we'll give you credit also. Otherwise, it was time barred under the provisions of law. They have brought a circular, we are ready to give you credit. But the problem with the industry is the credit is already accumulated. Again, paying and accumulating more, it will be a fictitious asset in the books of accounts with no utilization. 5% is the rate of minerals, lordship. RCM, they are asking to pay at 18%.
No, that is why certain cases okay.
In fact, when I came before your lordships to seek just a stay because there was a recovery notice, and all over India, when because of non-constitutional tribunal, all the high courts were seeing the matters and saying, okay, you pay 10% because there was statutory deposit of 10%. Had the tribunal been there, so we came before your lordships on that plea. Okay, we'll get a stay after 10, but your lordship stated no. Then we started with. It had to be decided anyway this way.
I did it is better for you.
Yeah, lordship, any day. My litigation goes.
Litigation goes and it's
Final full stop.
the amount which you have to
Of course.
pay. Now this is a 2000. It is only has been brought in the recent budget, the Finance Act,
Lordship,
wherein they have said that for first 3 years.
first 3 years, only 73 cases. 74 suppression fraud cases not come.
Those who have not filed it.
No, if you have filed it, you have to withdraw and then go. That liberty has been given.
Okay, anything else?
Lordship, this is my submission.
Page 118 of Eviction, that part of late authority.
Yes.
Correct. Paragraph 8. I find that.
Yeah.
Paragraph 8. I find that was the submission of the appellant that they had refundable exempted duty of 16 lakh 40,000 and all, and PLA reserve of 17 lakhs 19,000, amounting to total rupees 33 lakhs so and so, which they avail as a transitional credit as the refund mechanism applicable to such surplus reserve duty in the manner articulated in notification 20 of 2007, dated 25/4/2007, had been made redundant by the notification number 21 of 2017, by which notification 20 of 2007 was rescinded. They applied for a refund of amount of rupees 16 lakh 50,000, but a response to that same was not received by 18/7/2017, and therefore they found that the only viable means of obtaining the benefit of notification 20 of 2007 was to be availed such refundable exempted duty as credit under self-paid credit rule 2004, and thereafter avail such surplus as transitional credit in terms of section 1.
What is this, Mr. Kyle? The notification of 21 and even by which notification of 20 of 7 was rescinded?
Yes, sir. All the earlier notification were rescinded by the
But
GST.
we were reading which notification here?
20/2007.
That has only been rescinded by 2007 notification.
Says that.
When GST came, Lordship, then the government stated in GST regime, we will not give you that.
Huh?
When GST came, so 2017, they brought up a notification that the benefit of the earlier notification will not be given from July onwards because GST had come in.
Where is that notification?
That is 21/2017, which they have referred.
Where is that?
That I will not, I have not annexed in my petition because that is for subsequent periods. Means July, if I do a clearance of July, what I explained to your lordships, that had it been a case of July refund, then the government brought in notification that you are not entitled, we are devising a new scheme.
There is a new scheme, budgetary scheme was introduced
Lordships.
on 5/10/2017.
So one has to read this notification because this notification must have given something, some indication how it is been
So
taken
it was
to-
a two-line notification that all the schemes which were running before 1st July 17, all those notifications becomes redundant from the effect of GST because government is planning.
So therefore, as on 1/7/2017, this notification of
2007.
2007 was no longer in existence.
Yes, sir. Through this notification, they stated any future benefits will not endure to the NESSC.
So therefore, the benefit which you could have got in respect to these this PLA account and whatever may be, would have been only possible on the basis of
Oh,
an
done.
existence notification of that notification in the month of July, because you're right, you could have, if you see this particular notification, kindly see this 4.
Lordships.
The manufacturer at his own option
Lordships.
may take benefit of the amount of duty paid in the during the month under consideration other than so and so in the account maintained in the so and so issued by the Iman. Such a credited in the amount may be utilized by the manager for payment of the duty of Iman in subsequent months.
Lordships.
So this amount which is there for the month of May or June,
My case,
June, you could not have used it in the month of July.
July, they come up with, because they stated there is no excise policy regime. That is what I put up, Lordship, that had there been excise regime, I would have taken it in the excise return. So because excise return was done away with, they came with GST and they stated we'll bring a new policy.
Whatever maybe, you could have used these
In the month of
credit
June.
only in the subsequent month, which is month of July.
That is why, because of the change in regime, where do I get it?
No, Mr. Kalonia, the question is, it is, the word is in the subsequent months. So these credit could have been only availed in the subsequent months.
I go down to that, Lordship.
So if it is subsequent months, that is in the month of July, and that in the month of July, this clause 4 was not there of the notification of 20
Lordship,
of
it was there,
2007.
Lordship.
It couldn't have been.
I will show that notification to your Lordships.
If
I'm
it is
showing
not
that.
there, Martins,
I will show that notification to your Lordships.
so for you don't get the benefit under 4.
No, Lordship, I'll show that. What was that notification? That notification.
And if it was rescinded, it must have come up with some other notification.
Lordship, that notification 21/2017. I'll just open it, Lordship. One second.
So therefore, Mr. Kayal, the question would be, in view of the interim order, he has deposited this amount. Now, he's otherwise entitled to this amount?
Yes.
Because of revenue neutral.
Yes, that is,
Now, taking into account that for the first 3 years, it's your policy now not to impose interest or penalty. Is he not entitled back to the amount which he has deposited?
definitely he will be entitled to benefit under
Huh?
section 128 A capital A.
It's okay. But is he not now entitled to that amount?
This notification reads as under.
Let us assume you are liable to that
Lordship.
cannot use. Let us assume,
Lordship.
because this will create a problem to you again.
Lordship.
You have now deposited this 33 lakhs on the basis of an order being passed.
Lordship.
Amount has now been deposited.
This amount.
So the amount of duty
Tax.
has now been deposited.
Lordship.
As per 148 now, you are exempted from payment of tax and the interest and penalty.
Only interest and penalty.
Understood.
Lordship.
So are you now not entitled for that amount which you have already used it, now being not used because of now you have deposited this amount? Why?
28A. The scheme, the Lordship is talking about the new scheme. Referring to the new scheme which has
No,
been
no, the Finance Act.
Finance Act, 128A, that provides that if you pay 100% of the tax, then your interest and penalty is waived off.
As of now, you have paid.
I paid 100% tax.
Now, earlier, therefore, I'm saying, just for example, you had to pay earlier at that point of time 100 rupees.
Lordship.
You pay these 100 rupees now. At that point of time, what you did, you utilized your credit of 100 rupees
Lordship.
and paid it. Now, they say now that no. That 100 rupees which has been paid in that manner was not proper. You have to pay this 100
This
rupees
manner.
now along with tax and penalty. Okay. Now, when you approach this court directed you to pay this 100 rupees.
Lordship.
Now you have already paid that tax. Are you not entitled to that amount which you have paid earlier, used it?
I am entitled under 11B of Excise Act. That is what is falling from it.
So now you are entitled to that amount.
Lordships.
Interest and penalty is not there.
Interest and penalty is not.
So what is wrong now with this section? Why should we go into all these issues?
Lordship, the issue would be 2017 onwards, I have been taking the credit. They say it is refundable. I say they.
Whatever may be.
Lordship.
Are you not entitled to that amount now?
I'm entitled.
So these 100 rupees you will get back.
I will get back.
You have already paid these 100 rupees by virtue of this court's order. So 100 rupees has already been paid. Now in virtue of this Finance Act amendment,
Lordship.
you have already paid these 100 rupees, so nothing is remained.
Nothing is-
So that is being done with. So are you not entitled to the refund of 100 rupees?
I'm entitled subject to department then again not making my application under 11B as time bar. Because 11B says 1 year from the due date.
No, that can be taken care of by way of order because the matter was pending. So then your problem is solved.
I can take that route. Subject to your lordship giving directions to comply with the refund. I apply for the refund and they issue me a refund in a time bound.
Because of the order being passed, they're asking you to deposit, the problem is solved.
Yes.
Isn't it?
Lordship, but still lordship, 21 by 2017, it reads in exercise of powers under this, the central government on which said it is necessary in public interest hereby rescinds the notification of the government of India as per the below table, except as things done or omitted to be done before such decision. This is dated 18th of July
So your-
17.
Therefore, things which have been done earlier, it's okay. So you still maintain that 100 rupees.
Yes.
You still get those
I
100
will get-
rupees because of the fact that earlier it is being protected to that extent.
Lordship.
But to use this 100 rupees is stopped because that 4 is no longer there.
Lordship, utilization is not in dispute here, lordships.
No, utilization is the question. How do you utilize after, because 4 you don't have.
After I utilize for payment of outward supplies under GST.
Understood, but this you could have done after 4 was there, when 4 was there. Of clause 4
25/7.
of 2007. But when 4 is not there, how do you use
But
this?
lordship, in the entire proceeding, there is no dispute as to my utilization.
That
the
is
entire-
that is the problem. The entire dispute is that you have used it.
Lordship, they have challenged the show cause is only on the ground that I have taken the credit which I am not eligible.
Understood. That is what you have
Not
used
utilized,
it.
lordship, like let's say rule 14 of central excise rules, central credit rules. It says interest is payable if the credit is taken and utilized.
No, but you have, whatever may be, you have used that 100 rupees.
For payment of government taxes, lordship.
Absolutely. you have used that 100 rupees, but at that point of time you could not because you used it after 1/7/2017.
And Lordship, this was negated on 18 July 17. So anything up to
used it on
17 July,
30. You used it on 30/10/2017.
I took it in my tran one, that was the last date.
But therefore you used it on 30/10/2017. So this aspect, as such, why should we go into that aspect? Because this will have. We can very well say to that effect that look at now, therefore you have paid that.
Lordship,
It is legalized.
Lordship.
Now bring in section 128, 28 and give you the benefit of this. And then thereupon say that, okay, you will be entitled as the matter was pending all this along and long. So this period from that date till this day be excluded while computing the period of limitation.
In a
Then-
time bound manner, your Lordship may specify that. I will go in that.
Why that you have not asked for refund?
Lordship, that is the, Lordship, then it will arise a separate cause of action that will be a trouble. Lordship.
We have the advantage of getting you again. here.
Lordship, kindly
Let me pass the order at 2 o'clock in your
Get-
presence.
get for me.
Mr. Kyle, I thought about it, one thing. If I ask him to file the refund, statutorily he will entitled to interest. Instead, why don't you adjust that there and take the refund, let him take the refund of the amount which I have directed to pay, then he is not entitled to it. Get the point? Because if I allow it, then I'll pass an order that let it be deemed that the amount has been paid. But however, as it has been done on the basis of this, but he's otherwise entitled, he would be entitled to this amount. If this is the direction, then he won't be entitled to any interest. Get the point?
With regard to his earlier dues, Lordship provide that he can file application.
If I ask him to file an application under 11B, he will be entitled to interest under 11BB, which will have a huge repercussion upon the state. On the other hand, you are not in a position in view of the Finance Act, isn't it? So I think you take your instructions on this aspect. Because I think this is a better. So that amount which he has already paid to his PLA account, otherwise he is entitled to the refund.
Yes.
But that amount will be kept as if this amount which has been paid will be used as that. And the amount thereupon will be refunded, which I have directed him to pay, he has deposited. He will be entitled to the refund without
Sure,
going for
fantastic.
any further application.
Lordship, we are agreeable to it. Lordship.
I think that is a better option because the moment I do that, allow him to file,
That,
then the
Sure.
question of
17
this
from
is of
17.
2017 till today will be a huge interest, which you cannot take in view of this act.
Yes. That is.
Take your instructions on it,
That will be better.
because now he has paid that.
Yes.
Hey, Mr. Kananda.
See, we
But
are
the
agreeable to
making-
your proposal. Your Lordship passes that on. I am agreeable.
You are agreeable, I know, but let this thing also be corrected from there.
That's not it.
That.
That will be better.
Because I don't want to make this as a precedent also. This will have far-reaching implications. So if they do it, they say that that is okay. Yeah, because now they have the money.
Yes, on both accounts.
And in view of 128,
128.
they cannot take any interest on that amount. As that amount has now been paid by virtue of the court order itself. Taking into account, let him take any. I think that is a
Yes, sir.
better source. Because I thought that the moment the question of interest will.
Question of interest.
We'll have it just in the reopening.
Lordship,
You can close it then.
time I'll-
You just state your instruction. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S. Kyle, the learned counsel appearing on behalf of respondents. The petitioners herein have assailed the orders dated
31st March.
31/3/2022, as well as the order dated 2/6/2020. 31/3/2022 passed by the learned Joint Commissioner bracket Appeals, CGST and CX Guwahati is the respond number 2, and the order in original dated 2/6/2020 passed by the respondent number 3. And I have also assailed the communication dated 6/9/2023. It is seen that pursuant to the order, pursuant to the challenge being made to those orders and the notification, this court, by an order dated 21/12/2023, directed, issued notice and further state the interest as well as the penalty so imposed by the impugned orders. However, there was no stay on the principal amount to the tune of rupees 33,69,271. It has been further brought to the attention of this court that pursuant to the order dated 21/12/2023, the petitioner have also duly deposited the said amount of rupees 33,69,271. Agora amount 271. Meaning thereby that the principal amount have been duly paid. During the pendency of the instant petition, a statutory development had ensured in as much as by the Finance Act of 2024, Section 128A, 128
128 A, capital.
have been incorporated to the CGST Act 2017, whereby
First is the circular, second lordship, the second, the thick bunch is the circular, then the act, then the rules.
whereby
128, yes, lordship. That is the act.
any whereby if the amount of tax amount is paid in full pertaining to the period from 1st of July 2017 to 31st of March 2020, no interest under Section 50 and penalty under the Act shall be payable, and all proceedings in respect to the said notice or order or statement, as the case may be, shall be deemed to be concluded subject to the conditions as may be prescribed. Taking into account the insertion of Section 128A and the fact that the petitioner have already deposited the said entire tax amount, a question therefore arises As to question therefore arises in view of the admitted position that the petitioner is otherwise entitled to the said amount of rupees 33,69,271, which the respondents in their communication dated where the
Page
communication
43, Lordships.
Huh?
Page 43.
their
Annexure 3.
communication dated 9/1/2018 have admitted that the petitioner is entitled for refund under section 11B of the Central Excise Act 1944. This court have also taken note of that as during the pendency, the proceedings as to whether the petitioner could adjust the amount of rupees 33,69,271, which the petitioner had to his credit in his PLA account against the payment to be made under the CGST Act, has been the subject matter of issue and has been pending. Pursuant to the issuance of the show cause notice till date. This court had put a specific query upon Mr. S.C. Kyle, the learned standing counsel of the respondents, as to whether the respondents would like to adjust the said amount which have already been deposited by adjusting it from the PLA account, adjust the said amount. And by applying section 128A, the amount of tax, penalty and interest be waived. I've made an inquiry with Mr. S. C. Kyle, the learned standing counsel of the respondents, as to whether the respondents taking into account that the amount of the principal amount have been duly paid pursuant to the order passed by this court, would adjust the said amount and refund the said amount of rupee, refund the other amount, that refund the similar amount so deposited, which was otherwise refundable to the petitioner. It is the prima facie observation of this court that in the circumstance the amount is refunded, is adjusted, there is likely that there shall not be any interest towards the refund which the petitioner otherwise would be entitled to under the provisions of the Central Excise Act 1944. Mr. S. C. Kyle, the learned counsel, standing counsel, submits that he shall take instructions in that regard. This matter again on 7th of January 2020. I think that is a better,
I think that-
then in that regard, you wouldn't have lot problem out there.
list on eighth lordship if convenient, because seventh is a prefix matter.
Huh?
Eighth if convenient to you.
It is a motion day. You want to come on it very well, wait till 5:45.
No, what you say? Any other day? Lordship, ninth.
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 Doing it as part of that.
Just a observation also. In GST also, if I have paid through DRC 03, so I will, your lordship is indicating that I will file a refund under GST.
No. See, my order which I have passed,
Lordship, it stated
my
that
order,
that no, it is not a deposit.
it's not a deposit.
It's categorically recorded.
So therefore it shall not be, it is
No
not a
interest liability
deposit. So
will be there.
the question of interest would not come. there.
So I will file a refund claim under GST, not under the excise agent.
No, we'll direct them to refund you.
Refund, yes. What I have paid, they will refund.
Ah,
Lorships.
so
Without
then the
any
matter is over
lorships.
without going into all these complications.
Much of it. Grateful.
I'll just use one more word later on while writing it out, that taking into account the tax neutrality. What is that
Revenue
word?
neutral.
Revenue.
Revenue. Much of it. Grateful.
Item 14, fixed at 2 p.m.
This matter, my lord, after acquiring 11 lectures of land,
Hmm.
they are later trying to reassess and say that only 7 lectures are required. So the compensation payable for the dwelling house, they're not willing to pay that because they say that we don't require 11 lectures after the entire process is over, my lord. My lord, we produce the last order, my lord. and Request the plea.
Yes, who is paying for the talab? Yes, how? Hmm. Yeah. Madam, tell me one thing.
Well-
Once you pass the 3D notification, final,
Hello.
3D is for 11 lectures.
Hello.
What remains thereafter? Can you tomorrow come up and say, no, 3D, forget about 3D. 3D has a finality attached out there. NHI DCL may file a writ petition and say that we have not asked them to take 7. We have asked them to take 7 lectures, but they have mentioned it as 11 lectures. But they also can't do because the central government has done that. So you are to take 11 lectures. Matter ends there. What is all these type of communications and all? What is the impact of a 3D notification, madam?
Yes, my lord, sir. Final, my lord, that's cannot,
That cannot remain. Yes, Mr. C. Borua.
my lord, taking the prize.
Whether NHI, DCL wants or doesn't want, they may throw it to the dustbin, whatever they may do with the land that is their lookout. But one 3D notification comes and there is a prescription out there with the coming of the notification, the land vests upon the state. You cannot resile from there.
Here, what happened? TA, TD notification.
There's no 3D.
It was not TD, not passing TD. They ultimately, I think Salah has said it, what manner it is, you don't know. Because we were sent for 3G, then we have paid for 11 less or whatever.
No. Has the 3D notification been passed?
Now, my letter friend will say on this point because of this it is by Salah.
Mr. Mohanto, whether 3D notification has been issued?
My lord, my,
3G.
my specific.
3G is nothing. 3G is money.
Now, my lords, after pursuant to filing of the writ petition, my lords, they come up with an affidavit saying that although 3G has been published and the land is
3G
acquired.
has no value.
Yes. The earlier notification, it seems it's not there, but I being a, my lords, a widow, I'm not aware of it. 3G was issued and I've been paid money for the 11 years.
3G has no value unless 3D is passed.
Then the entire acquisition would go, my
So
lord.
you have not acquired anything.
My lord, I'll have to take instruction, my
So if you have not acquired anything, why you are disturbing him?
stand maybe in the next Monday, my lord.
Huh?
Monday, my lord, I'm sorry. Monday.
Well, the statements are contradictory, my lord. Now they are saying the
Maybe.
notices were not published, but nonetheless they say, no, we have already acquired 7 lectures out of the 11 lectures. So they require
How
7
do you acquire without the 3D? This matter again on 2012-2024, on which date Miss Yushama, the learned additional senior government advocate shall obtain instructions as to whether any notification has been issued under Section 3, capital D of the National Highways Act 1956.
My,
Item 34 and 35.
Why there are two writ petitions?
And one is for the buffalo fight and one is for the bully fight. To writ petition because there is an SOP which has been issued by them by notification if your lordship is holding 466 of 2024.
Hmm.
This is a notification of 27th of December 2023. Page
466.
466.
Page?
Page 42. Page 42 is the notification.
Okay.
The notification where lordship will find at page 43.
Now,
Now, my lord, we challenge this notification.
why?
We challenge the notification because we are saying that there is a contravention of the provision of the Act. Two provision of the Wildlife Protection Act and Prevention of Cruelty to Animals Act 1960.
Hmm.
And there is a judgment of the Honorable Supreme Court. As on date it stands. Apart from that constitutional bench judgment, which is only in respect of 3 states, that is Maharashtra, Tamil Nadu and Karnataka. Now, if your lordship looks into the Act and the notification which has been issued at page 42, my lord. First, kindly look into the Prevention of Cruelty Act, my lord. Take a look.
একটু হে কিছু ভয় করি।
My lord. Video. Huh? What you have given or not? My lord will kindly.
Which judgment you are referring
My
to?
lord, I am referring to Prevention of Cruelty to Animals Act 1960.
Okay.
1960. This is kindly look into section 11, my lord. Section 11. Section treating animal cruelty. 11M 2, my lord. 11M.
Yes.
Treating animal if any person solely with a view, my lord will kindly say, solely with a view, providing entertainment, confine or causes to be confined any animal, including type of animal, so and so, incite any animal to fight or bet any other animal, or so and so. So here too, my lord, buffalo, M2, my lord will kindly say, M2, incite any animal to fight or bet any other animal. What you got it, my lord? So
So you
now,
come under M2.
M2, yes. M2. And there is a penal provision, kindly see, my lord. So whoever violates this provision, my lord, so he shall be punishable, kindly see, after O, my lord. He shall be punishable in case of first offense with fine, which shall be so and so. And in the case of second or subsequent offense committed within 3 years for so and so, so and so. So if your lordship looks into it, there is a violation of the provision of 11M2
Hmm.
and N. Kindly see N. N also there is a violation. Organize N, 11N. Organizes, keep, uses or act in a management of any place for animal fighting or the purpose of baiting any animal or permits or offers any place to be so used or receives money for the admission of any other person to any place kept or used for any such purposes or so and so. So my case is covered by 11M2 and N. And which is directly in conflict with the judgment of the Supreme Court, which stands as on today also it holds good, of A. Nagaraj, which your lordship will find at page 47.
That's fine.
Page 47.
Yes.
If your lordship looks into the operative portion at page 89. 89 of paragraph 77. 89.
Hmm.
We therefore hold that AWBI is right in his stand that Jallikattu Bullock race and such event per se violate section 311(1)(a) and 11(1)(1)(m)(2) of PC Act, and hence we uphold the notification dated 11/7/2011 issued by the central government. Subsequent bulls cannot be used as performing animals either for the Jallikattu events or Bullock race in the state of Tamil Nadu, Maharashtra or else in the country. We therefore make the following declaration direction. Because, while not pausing for a moment, there was a notification which was issued by the government of India by Gazette notification at page 41. If you see, Lordship, kindly see 41.
Page?
Page 41. Kindly see 41. Because they reflected about this notification. If you see at page 41, on the right-hand side column, New Delhi, 11 July, in excess of power conferred by section 22 of so and so, supersession done. So these are the performing animals which there is a restriction. Bears, monkey, tigers, panthers, lions and bulls. Lordship got it, my rules. So these three states, namely, my lord, the Maharashtra, Tamil Nadu, and Karnataka, they were holding the three events, which was totally in violation of the Gazette notification. And while deciding the case by the apex court at page 89, they hold this, my lord, that there was a violation of 11(1)(m).
What is AWBI?
AWBI, Animal Welfare Board of India. Animal Welfare Board of India. Because, my lord, these three states had the act, because their act was inconsistent with the central act. If your lordship looks into it, because we don't have an act here, by an SOP they have come up, which is totally in contrary with the judgment of the Supreme Court. If your lordship looks into it, para 77 and 89, we declare rights granted to the bulls under section 3 and 11 of PCA Act.
Has the parliament thereafter amended the law?
I'm sorry, madam.
Has the parliament thereafter amended the law?
This parliament has not amended, stands as on today also it holds. Now, what has happened? Three states, my lord. Three states, Tamil Nadu, Maharashtra, and Karnataka, my lord. While this matter was taken up by the apex court in Nagraj, subsequently, my lord, they amended. And they were in consistency with the central act. So, when by a constitutional bench, when the matter was taken up in 2023, I have annexed it. The learned constitutional bench has said, now there is absolutely no problem because they have come with an act which is amended and they have filled up the gap. If your lordship looks into it, their judgment of the apex court, constitution of 5 judges.
No, they have, since the amendment was carried out in terms with by taking the presidential consent.
Yes, right.
And as such, it is not
Correct,
part under
correct,
Article
right.
350.
They have taken the assent of the president and they said, they have filled up that. So, in that view of the matter, there is a consistency and they have taken the assent of the.
So, Assam has not done that.
It's not done it.
So, without an amendment being made by Assam,
Yes.
nothing remains.
Nothing, yes. That's our case, Madam. That's our case.
What should even the act is not there.
Huh?
So we had to follow the direction of the apex court earlier in the earlier case. So we had imposed a total ban. Then some petitioner came before this honorable court that it's a tradition, so it should be allowed to hold the fill up fight during month. So some higher media was because
Cannot be a via media. The thing is,
for
we
this
want to
particular
do it,
time period,
you amend this act by way of taking a presidential consent. Otherwise your SOP, whatever court passes on order cannot go against the Supreme Court directions.
But if I am, but it may not be my lord. Only thing is, I cannot make that sufficient lordship because in that case, I took that plea that we have following the.
Where is the judgment of the hour court?
That judgment, for your lordship will finally see the High Court's order at page 140, 148. 148. And final order is at page 156. If your lordship looks into 148 and kindly look at 151. See 151, my lord.
So here the court did not decide anything.
No,
Send
court
it to
did
you.
not decide.
Send it back to the chief secretary. Take it easy.
Now SOP,
So thereupon you have come up with this SOP.
yes,
But your SOP has to be in conformity with the judgment passed by the Supreme Court
that's our
as
case.
well as the act. It is
Is
not
there
done.
the Supreme Court earlier judgment still holds the field.
Yes.
Because
Earlier, you can very well. You can do so by
You can do so.
proposing an amendment under Article 354 by taking the presidential consent. You having not done matter.
Because those three acts were enacted under 2017 of these three. Concurrent.
No, very well, you can do it. But you see, in view of the Article 254, you have to, if you can take the presidential consent, you can override this provision. Then go for a press SOP.
So clear, no problem.
Set aside this SOP.
Culture and say that, but only I cannot make that submission because unless I.
I'm not making any submission. You was making a submission that in terms with the leave being granted by this court, by that order, you have taken a decision in the SOP. Your
For a
submission.
particular case.
See, I am who am saying that you want to do it, do it.
Right.
First amend it. Seeking an amendment which Karnataka, Tamil Nadu have done, you do the same thing. That's it.
That's our case. That's our whole case. You can do it, absolutely no problem.
Okay,
have
now
to-
what do you say about the
No,
Bulbuli file?
Bulbuli is directly they can't. My lord, I'll show it. How they can't in Bulbuli. My lord will kindly see Wildlife Protection Act now. That's totally they can't do it. Wildlife Protection Act.
Yeah.
So my lord will kindly see section 9. See section 9, my lord. Section 9. Prohibition of hunting. No person shall hunt any wild animal specified in Schedule 1 and 2, except as provided under 11 and Section 12. Now, if your lordship looked into schedule, birds, kindly see Schedule 2. That part B is birds.
Hmm.
Schedule 2. That's a table is there. Part A mammals, part B is birds.
You're
So if
saying
your
about
lordship
serial
goes-
number 50,
I'm sorry,
50?
50 63, my lord. 63.
Huh?
63, serial number 63 birds.
Red-vented bulbul.
Yes. So, red-vented bulbul, now if your lordship, there is a restriction which we can't. Now, if your lordship looks into definition of 16, kindly see 216 now. Absolutely, there is a bar. 216, kindly see, my lord. Definition 216. 216. Hunting, which is grammatical variation and cognate expression includes, be kindly see, my lord. Capturing, coercing, starring, trapping, driving, or betting any wild captive animal, every attempt to do so. So, for the purpose of hunting, you cannot capture it, which is barred under the schedule. And also, it will relate to the Prevention of Cruelty Act. That also will apply. 11 directly will again apply. Any animals. So now, 11, my lord, here direct prohibition is there. Direct prohibition is there. Under 9, section 9,
11 means?
I'm sorry.
11 of this one.
Yes, yes. Section, yes, same.
No, but that doesn't have a notification.
Which one, man?
Bulbuli bird has no
They
notification.
have this notification. No, notification SOP has been issued.
No, this
Oh,
SOP
that does happen. Yes, that doesn't
it
happen.
is not there because it is in the Schedule B.
Yes, yes, oh, of course. Right.
So, Mr. Bijay Talukdar, to the dictate?
But-
The dictate?
Only it may not be put on mind because there is no written stand.
You hear what I say? I may use adjectives out there, vociferously, argue, strenuously put in your submissions.
Because my difficulty is in the other case. I took a reference that now they have come. There's
No, I'm not on that. Other cases, okay. They have the court, what have the court have there, let us ask the chief secretary to take a call. And pursuant to that, whatever they have done is they have done.
possibly time was so short, therefore.
Maybe, but If the chief secretary is to take a call, the chief secretary has to take up a call by taking into account the law of the land. The law of the land is in the Supreme Court judgment as well as these two acts. And if it has not been taken into consideration,
These acts
that's
are all
bad.
discussed in those. They are all discussed.
Where?
Supreme Court. judgment.
No, these have been done, so therefore it has to take into
It has to
account the
come
law of the
within the
land.
four corners.
Okay, heard Mr. The learned senior counsel assisted by so and so. Learned counsel's opinion out of the petitioner petitions. Mr. B.J. Talukdar, the learned senior counsel appears on behalf of the respondent numbers 1 and 2. 1 and 2. Who has issued this notification?
This notification.
1 and 2. Who appears for 3?
One and three, nobody appears.
And 2, you have to appear, Home and Political Department.
Yes,
1 and 2. 3,
nobody has appeared. Anyway, notice.
and has appeared on behalf of the respondent number 3. The writ petitions, take your seat, Mr. Das. Both the writ petitions have been filed challenging the order, challenging the notification dated 27/12/2023 passed by the governor of Assam through the joint secretary to the government of Assam Home and Political Department dated 27/12/2023, whereby whereby the government of Assam had allowed the bullfights to be organized in all places where it has been done traditionally. Whereby the government of Assam have allowed both bullfights and bulbuli bird fights to be organized in all places where it has been done traditionally with specific provisions for regulation by the district administration to ensure that cruelty to animals are not allowed to be inflicted. By the said notification, various SOPs have been also issued as to how the said fights could be, how the buffalo fights, bracket mozuls, and the bulbuli fight, bird fights could be organized. Full stop. The legality and validity of the said notification dated 27/12/2023, hereinafter referred to as the impugned notification, is the subject matter of challenge on the grounds that it violates the provisions of the Wildlife Protection Act 1972, bracket for short, the Act of 1972, comma, semicolon, the provisions of the Prevention of Cruelty to Animals Act 1960, for short, the Act of 1960, as well as the judgment of the Supreme Court rendered in the case of Animal Welfare Board of India versus A. Nagaraja and others, reported in 2014, 7 SCC 547. Mr. Didas, the learned counsel appearing on behalf, no, taking into account the above challenge, this court finds it relevant to note down the respective submissions made by the counsels appearing on behalf of the parties. The DIDA, the learned senior counsel appearing on behalf of the petitioners in both the petitions, has drawn the attention of this court to section 11 of the Prevention of Cruel of the Act of 1960, and more particularly to section 11 bracket 1 M and N bracket M bracket N. The learned senior counsel submits that from a perusal of the above above sections, it would be seen that that if any person solely with a view to providing entertainment incites any animal to fight or baits any other animal, or for that matter, organizes, keeps, or uses or acts in the management of any place for animal fighting, or for purposes of baiting any animal, or permits or offers any place to be used, to be so used or receive money for the admission of any other person to any place kept or used for any such person, shall be punished as per the said provision. The learned counsel therefore submits that there is a penal provision in respect to inciting any animal to fight or bait any other animal, or to organize any place for animal hunting. The above being the learned, it is further contended by the learned senior counsel that the above being the prescription of law, the learned the state government would not have issued a notification, the impugned notification, thereby permitting the buffalo fights, bracket mozus, which have been sought to be done. In that regard, the learned counsel has also further submitted that there is a notification issued by the Ministry of Environment and Forest dated 11/7/2011, whereby the central government, who has the pervasive control, specified that that amongst the various animals shall not specified that bulls amongst many other animals shall not be exhibited or trained as performing animals with effect from the date of publication of the said notification. The learned senior counsel therefore submitted that these bulls under such circumstances cannot be in any manner exhibited or trained as has been sought to be done by way of the impugned notification. The learned senior counsel further drew the attention of this court to the judgment of this court, of the Supreme Court in the case of A. Nagaraja Supra, wherein the Supreme Court had categorically observed that the rights granted to the bulls under section 3 and 11 of the Act of 1960, read with Article 51A, capital A, bracket small g, and h, small h, cannot be taken away or curtailed except under section 11.3 and 28 of the Act of 1960. The senior counsel further submitted that the Supreme Court had categorically laid down, had made declaration of law in terms with Article 141 or 42 of the Constitution, 141 of the Constitution, and as such, the said law cannot be violated. And as such, the impugned order, impugned notification, and as such, as the impugned notification goes against the very mandate of the law laid down by the Supreme Court in the case of A. Nagaraja Supra, the impugned notification is liable to be set aside and quashed. The learned senior counsel further submitted that the judgment in the case of A. Nagaraja Supra was rendered primarily in the case in respect to the Dalikut Katu and block cart race. Subsequent thereto, both subsequent thereto, the state of Tamil Nadu, the states of Tamil Nadu, Karnataka, and Maharashtra have made amendments, have carried out amendments by taking the presidential consent. And this very aspect of the matter would be seen from the judgment of the Constitution Bench of the Supreme Court in the case of the Animal Welfare Board of India versus Union of India, dated
That is at page 92.
18th of May 2023, whereby taking into account that the presidential consent assent was taken, the Supreme Court had
At page 145.
that the Supreme Court had the Constitution Bench of the Supreme Court had held that the amendments so carried out, having received the presidential assent, there was no flaw in the state action. The learned senior counsel submitted that the state of Assam, if intended to carry out any bullfight or the bulbuli fight, would have resorted to by carrying out similar amendments but without carrying out similar amendments by way of an executive instruction, such exercise of power is not conceivable in law. Mr. B.J. Talukdar, the learned senior counsel, appearing on behalf of the respondent, submitted that that a coordinate bench of this court had, by an order dated 10/10/2023 in WPC number 73/2016, had held that the bulbuli fights, bird fights, as well as the mojus are long-standing traditions being performed in the state of Assam during the festival of Magh Bihu. Be that as it may, the learned single, the coordinate bench, taking into account that it is a long-standing traditions, and further, there is a necessity to address the well-being of the people, of the animals, have referred the matter to the Chief Secretary to take a conscious decision by keeping into account paragraph 44, bracketed Roman 2, of the judgment in the case of A. Nagaraja, no, a judgment in the case of Animal Welfare Board of India, 2, Supra. The learned senior counsel, appearing on behalf of the respondents, further submitted that in tune with, by taking into account the judgment in the case of Animal Welfare Board of India, 2, the impugn notification has been passed by
It has to be saying that it has to be done in a regulated manner.
have been issued, whereby various SOPs have been issued SOPs have been mandated so that the list of
No physical harm.
the least physical cruelty is inflicted upon the animals and the birds. The learned counsel further drew the attention of this court to the SOP, wherein it is SOP, which is a part of the impugn notification, wherein it has been mandated as to how, wherein it categorically stipulates that how the animals and the birds are to be treated. And the learned senior counsel further referred to the allegations so made in the petition in so far as mojus and bulbuli fights are concerned, and submit that the stand so taken by the petitioners in their petition are duly, the allegations so made in the writ petitions in respect to the mojus as well as the bulbuli fights, bird fights, have been duly addressed in the SOPs. He therefore submits that in taking into account the SOPs so included in the impugned notification duly addresses the well-being of the animals and the birds. No interference is therefore required in the instant proceedings. Anything more? Let me come back.
Only one thing may be necessary. They have filed some FIRs because conducting such modes.
Why should we go into this FIR business?
That was
Those
at that
were
relevant
taken
time.
care of, my.
That the law will take care.
Yes.
You know. Entry 17 of the list 3 of the 7th schedule to the 7th schedule of the Constitution. Relates to prevention of cruelty to animals. In exercise of the said power so conferred, the Act of 1960 was enacted by the Parliament to prevent the infliction of unnecessary pain or sufferings on animals, and for that purpose to amend the law relating to prevention of cruelty to animals. Section 3 of the Act of 1960 deals with the duties of persons having charge of animals, which is mandatory in nature, and hence confer corresponding rights on the animals. Rights so conferred on the animals are thus the antithesis of a duty. And if those rights are violated, law will enforce those rights with legal sanction. A perusal of Section 3 of the Act of 1960 imposes a primary duty on the person in charge or care of the animal. Is to ensure the well-being of the animal. The said section has two limbs, which are: a duty is cast on the person in charge or care to take all reasonable measures to ensure that the well-being of the animal, as well as a duty to take reasonable measures to prevent infliction upon such animal of unnecessary pain and sufferings. Section 11 generally deals with cruelty to animals. The said section confers no right on the organizers to conduct any bullfight as held by the Supreme Court in the case of A. Nagaraja Supra. Section 11 is a beneficial provision enacted for the welfare and protection of the animals, and it is penal in nature. Being penal in nature, it confers rights on the animals and obligations on all persons, including those who are in charge or care of the animals. It is further seen from Section 11. More particularly, Section 11(1) M and N, to which the learned senior counsel appearing on behalf of the petitioner had laid emphasis that if any person solely with a view to providing entertainment incites any animal to fight or bait any other animal, or organizes, keeps, uses, or acts in the management of, any place for animal fighting, or for the purpose of baiting any animal, or permits or offers any place to be used, or receives money for the admission of any other person to any place kept or uses for any such person, shall be punishable with an offense, with the first offense with a fine which may extend up to ₹50, and in the case of second or the subsequent offense with 3 years of previous, within second or subsequent offense committed within 3 years of the previous offense with a fine which may not be less than ₹25, but which may extend to ₹100, or with imprisonment for a term which may extend to 3 months, or with both. This court have also taken note of the notification issued by the government of India dated 7, 2011, which have been issued in exercise of the powers under Section 22 of the Act of 1960. Whereby the central government had specified that the animals mentioned in the said notification, which includes bulls, shall not be exhibited or trained as performing animals with effect from the date of publication of the said notification. This power so exercised by the central government is in tune with Section 22, bracket Roman 2 of the Act of 1960. In the instant case, it is very categorically seen that the bull, for the purpose of carrying out the bullfight, the bulls have to be exhibited. As would be apparent from a perusal of the improved notification itself. So, the SOP mandates certain certain regulations, mandates certain certain requirements. But the fact that there is a restriction so imposed by the by the notification dated 11/7/2011, which issued by the central government, which still holds the field, categorically appears, it therefore appears that the impugned SOP, impugned notification, is contrary to the provisions of Section 22, Roman 2, read with the notification dated 11/7/2011. The very opinion of this very opinion arrived at by this court is further supported by the observations so made by the Supreme Court in the case of A. Nagaraja Supra, wherein at paragraph number 77, they say the very notification dated 11/7/2011 have been duly upheld. Under such circumstances, it is therefore the opinion of this court that the impugned notification, insofar as permitting bullfight, is contrary to the notification dated 11/7/2011, as well as Section 22, Roman 2 of the Act of 1960. This court further is of the opinion that Section 11 M and N of the Act of 1960 further prohibits any animal fighting and prohibits inciting any animal to fight, as well as from organizing any animal fight. These being penal provisions, it is for the state to protect the said rights of the animals, being a welfare legislation. The SOP, therefore, appears to be in contravention to section 11 M and N of the Act of 1960. Moving forward, this court now would like to take up as regards the bulbuli fights, bird fights, which have been allowed by the impugned notification. It is seen from the impugned notification that traditionally these bulbuli fights were being carried out since the time of the Ahom regime. Be that as it may, with the enactment of the Wildlife Protection Act 1972, it is seen that by virtue of section 9 of the Act of 1972, no person is permitted to hunt any animal specified in Schedule 1 and Schedule 2, except as provided under section 11 and 12 of the Act of 1972. Apparently, a reading of section 11 and 12 of the Act of 1972 cannot be applied to the facts in respect to the bulbuli fights. This court further finds it relevant to take note of the definition of hunting as defined in section 2(16) of the Act of 1972, which is reproduced hereunder. From the above quoted definition of the word hunting, term hunting, it transpires that it not only includes killing or poisoning of any wild animal, but would also include capturing, forcing, snaring, trapping, driving, or baiting any wild animal, wild or captive animal, and every attempt to do so. This court also finds it very relevant to take note of Schedule 2 of the Wildlife Protection Act of the Act of 1972, and more particularly to to serial number 63 and 64 of Part B, wherein there is a reference to red-vented bulbul and red-whiskered bulbul. In view of the above, in view of the same, and reading conjointly with section 9 of the Act of 1972, it would be there conjointly with section 9 of the Act of 1972, Act of 9 and section 216 of the Act of 1972. It would therefore be seen that the bulbuli birds in question cannot be hunted as per the definition of the section 216, as per the definition mandated in section 216 of the Act of 1972. It is also seen that the definition includes the word capturing, meaning thereby that these bulbuli birds cannot also be captured. Under such circumstances, to permit an exhibition of bulbuli fights as mandated in the SOP and the impugned notification, irrespective of the fact that certain regulated measures have been mentioned for the well-being of the bulbuli birds, cannot save the impugned notification insofar as the Bulbuli birds are concerned, Bulbuli bird fightings are concerned, bird fights are concerned, as the same is contrary to the provisions of, contrary to the mandate of the Act of 1972.
There is also a penalty provision under 51. That's 51 of Wildlife Protection Act. Penalty, 51.
This court further takes note of that Section 51 imposes penal provisions upon violation to Section 9 of the Act of 1972. And therefore, it is also the duty of the state to maintain, to not permit such violation. This court have also duly taken note of the judgment of the Constitution Bench in the case of Animal Welfare Board 2, wherein it is seen that in the states of Maharashtra, Tamil Nadu, as well as Karnataka, various amendments have been carried out to the Wildlife Protection Act 1972. Wildlife, no, Act to the Prevention of
Cruelty.
to the Prevention of Cruelty Act 1960
1960.
by the respective state government by taking the presidential assent. It is also seen that in view of the amendments being carried out by the respective state governments to the Act of 1960 by obtaining the presidential assent, the Supreme Court had held, the Constitution Bench of the Supreme Court had held that the said enactments, are not contrary to the provision, are not ultra vires the provisions of the Act of 1960. However, in the instant case, it is noticed that the state of Assam, instead of making amendments to the Act of 1960, making state amendments to the Act of 1960, as has been done by the state of Maharashtra, Karnataka, and Tamil Nadu, have resorted to overcome the Act of 1960, as well as the judgment Act of 1960, the Wildlife Protection Act 1972, as well as the judgment of A. Nagaraja by way of an executive instruction, which, in the opinion of this court, is not permissible. Accordingly, both the writ petition stands disposed of with the following observations and directions. Number one, the impugned notification dated 27/12/2023, passed by the Governor of Assam through the Joint Secretary to the Government of Assam, Home and Political Department, dated so and so, is set aside and quashed. The state of Assam is further directed to ensure that that there is due compliance to the provisions of the Act of 1960 as well as the Act of 1972. So, with the above observations and directions, the petition stands disposed. So before Mark, you got something which we would have otherwise witnessed.
I think my lordship, the state may be at liberty to do in terms of
The setting aside of the notification shall not debar the state to take recourse to the provisions constitutionally permissible as as permitted by the constitution.
All IAs are pending, it's all closed.
Pending applications, if any, stands closed.
I'm deeply obliged.
Yes, Lordship, in this matter, we have received the instruction, Lordship, but we have received the instruction, Lordship, but my senior Miss A. Dan has undergone through a surgery, Lordship. So maybe fixed after vacation, Lordship.
My lord, my heard it, my lord, simple matter, let it be part of my lord. Let the gross. Issue is, my lord, they are in unauthorized occupation of the petitioner's land. The state government have given a report that this land has not been acquired. The CRPF authorities also couldn't furnish any document when the joint verification was called for.
What is your instruction? What does it say?
Lordship, we have applied to the circle officer and the DC of the circle officer replied that these documents are not with us. It may be before the district commissioner.
Have you acquired the land?
Lordship, that Lordship, as per their Lordship, there is a letter number which says it was acquired. Now, Lordship, copy of the acquisition order number so and so 6-15/74 dated 31/3/75. From that document, it seems Lordship, it was acquired and given to him, CRPF Lordship. Otherwise, Lordship, how CRPF will come here and settle Lordship without acquisition Lordship?
You never know.
That was it.
That was
Army people,
Separate-
CRPF people, they do everything.
Separate land matter. This acquisition order which my learned friend is referring to, that is in respect of 10 bighas of land. It is everything in the affidavit, their affidavit. It is in respect of 10 bighas of land which the government has acquired and given to the CRPF. And the five bighas land which they are occupying by constructing a pump house, that land has not been acquired. Even the circle officer has asked the CRPF authorities that you come for joint verification, madam. In the affidavit of the state government, it is clearly stated, my lord, this land was not acquired, and they don't come for joint verification also.
But that I can see this Lordship.
You have you have only taken 10 bighas. Are you in possession of 15 bighas?
Yes, they are in possession.
15 bighas.
Yes, that which has been allotted to them, they are then, and along with these 5 bighas of the petition.
Yes, why? They are the protectors of our freedom and now they are taking away our rights under Article 300A.
But as per these letters, Lordship, that 10 bigha is also only seen that 10 bigha and 1 kathal land has been taken by the state.
So, if you are in possession of more than 10 bighas, you have to vacate it. Pay them the requisition expenses.
But my only anxiety is this petitioner, sir, my lord, octogenarian 80 years, my lord. Now, suppose was someone.
They don't have sons and daughters.
The one doesn't have, my lord, then again, some matter of 2014.
Take advantage, you are a lawyer.
Then, my lord, 2014 matter again substitution, my lord.
Petition, no problem, don't worry with that. You have not taken anything. Who pays for the state? State has filed an affidavit. What is the affidavit filed by the state?
Because of land also, madam, allotted to the respondent. 10 bighas as well as another 2 bighas of common land. Paragraph 10 of our affidavit, madam, page 69.
Where's the affidavit? And then
Fine,
16,
17 December 2000.
subdivisional landowner Kapru Metropolitan. As per record of respondent after the hearing in between the petition and response. The adjournment was contacted. You seen that dark number 49 and 5 of Patta number in. Two scenes in.
আমি দুটো গভর্নমেন্ট ল্যান্ড আছে Into the needful now. Don't have to comment now.
Now, where is it mentioned? Who is the owner of? You are the owner of what
Yes.
land?
Yes, but that, Lordship will take up the writ petition, my lord. Lord will kindly come to page 30, page 30.
Ah.
You got it, ma'am? Page
Tag
30,
number 5 and 49.
or yes,
5 bigas, 4 lectures in possession of so and so.
so and so, so and so. Tag number so and so, so and so. You are requested to appear and submit necessary documents pertaining to the subject matter as well as before the undersigned before so and so, so and so. So this was there. Now, then your lordship will turn to my lord. The page 37. And the acquisition order which they are referring to, my lord, that is at page 35, and the type copy is at page 35M. The type copy is at page 35. Certified that I so and so, so and so, and so, on this so and so received from so and so, Sonapur, the possession of KP land measuring 10 bigha, 1 lesser, 12 brothers of
What
Sarkari
is
land,
KP land?
Patta land. That was Patta land 10, the land 10 bigha,
Measuring
which
10
was
bigas,
acquired.
1 katha, 12 lectures of Sarkari land. How can it be Sarkari land if
No,
it is Patta land?
KP Patta land measuring 10 bighas, 1 kata 12 lectures of Sarkari land, and 1 bigha 2 kata 13 lectures of village Sorutari, 2 bigha 2 katas and 10 lectures of village Sorutari. Now, your lordship will next come to my lord, page 37, my lord.
Or total land 14 bigas.
Huh?
After lordship, it is written all total land bill.
14
measuring
bigha,
14
1
bighas.
kata, 1 lectures. For total,
Total 14, they are saying 10 bigas, but we are occupying 15 bigas.
14 bigas.
Here, lordship, from this.
14 bigha, 1
14 bighas.
1 kata, 1 lecture. Total it comes to 14 bigha, 1 kata, 1 lectures. Page 35, amen. Then
And-
your lordship will come to page 37, my lord. Page 37, this is the, my lord, report of the circle officer. My lord, your lordship will come to, my lord, para 1, 1, my lord. Fourth line, my lord, from top, out of the total land, what you got it, my lord, page 37, out of the total land measuring 5 bigha, 4 kachas of dag number 5 and 49 in patta number 31, under the ownership of pattadars of so and so, so and so, so and so, is occupied by CRPF, putting water pump house station on the said land since 1975. Then she will turn to next page and last part, last para, my lord. It may be mentioned, my lord. It, page 38, it may be mentioned that as per the revenue record available in this office, there is no record of any order of acquisition or compensation of the said land used as water pumping house station by CRPF situated at so and so, so and so, or paid to the original patta holder, so and so, so.
You see, the state has to come up with some document to show that they are, the fact that they are the owners of this land is in dispute. Disputing it.
My lord, because we could not find the documents, my lord. We could not find the
If you
documents.
don't have the documents, matter is over. The fact that from when are they in possession, the CRPF?
Lord, this CRPF that Khanapara, when they have built up this CRPF campus, so this land is adjoining to their land. So at that time, my lord, they have built a water pump house,
When?
since 75.
But why are you doing all this?
My lord, we have been pursuing the matter with the authorities, my lord. So we thought that they will come and they will settle, my lord. When they have not done anything, then only, my lord, we have filed this petition.
You approached in 2014. Then 14 years and another 25 years, 39 years. Why you are after such a day, basically they lose the records?
But because they have already constructed their farm camp house over there. So our land was nearby, so we were, using.
How
that
did
land
you,
for-
why didn't you protest at any point of time earlier?
Because at that time, my lord, when they have built it, my lord, we thought that the land has been acquired and the land which was allotted to them, they are in possession of that.
Then-
So subsequently, when we came to know that this pump house also they have built over there, then my lord, we approached the authorities.
So you earlier thought that they have acquired the land,
Yes, my lord, we thought that they were required that when nothing.
but
could
you have
be
not
produced.
received any compensation.
That is why, my lord, we thought.
Did you
that
apply
we were under
anywhere
the-
that you
yes,
pay us the
that is why,
compensation
my
for
lord,
this?
Yes, they are saying whenever we approach them, they said that no, we have been approved, it has been acquired, the government has taken over.
No, the problem is that if you don't, they lose their documents. Can we say, can this court ask them that you have to produce those documents because of the fact that the 39 years have passed by?
My lord, when, my lord, the circle officer is saying that there is no report, there is nothing on record to show that this land has been acquired. The report of the circle officer is there. The circle officer asks for the CRPF authorities that you come for a joint.
PRBF also may not have those documents.
Lord, it's a government office, my lord, any they what should have.
They
some
may
document.
have, at
They
that point
should-
of time, they must
My
have
lord, when
took it
they
off.
can produce this document of, my lord,
But can we
1970
today
page
ask
40
them,
40
taking into account that you have slept over your royal rights for 39 years?
Lord, my lord, tax court has held in various judgments, my lord, that 300A, although it is not a fundamental right, as per constitution, it is a constitutional right, and the person, no one should be deprived of their constitutional right, save and except in accordance with law. my lord. And when they can produce this page 43A, document of 1975, because they are saying, all along they have been saying that, yes, this is the order by which the land has been acquired and possession has been given over to the CRPF authorities. That is at page 43A, my lord. Now, when they could produce this document, my lord, of this acquisition order, my lord. So in 2012 order,
So from you, 10 bighas of land has been
Well,
taken.
2005, my lord, we have been, the first notice which have issued in 2005, my lord, page 25,
And also 20 years.
20 years. my lord. So, my lord, when they have built up there, my lord, this CRPF campus, my lord, we were not allowed to go inside that campus. my lord.
Why are you going? Why do you
Now-
need to go inside the campus? Are you
Madam,
going to find documents
Then-
there?
then- so we were under the bona fide impression that, my lord, they have acquired it.
So,
So,
bona
my
fide
lord, if they
requirements,
have
okay,
acquired it,
pay
we have
as on that date.
we
They
have,
were bona fide impression, pay that. At that point of time, Hunapur rent at in 1975.
but
I think that,
acquisition, my
I
lord,
think it will be 1,000 rupees per bigha. Less, I think, 250 rupees per bigha. Take it, 250 rupees, 5 bighas,
then let them, my lord, vacate the land, hand
1100.
over the possession.
1100 a year, we finished and
Let them
completed.
pay the rent and hand over the
Yes.
possession of the land, my lord.
Yes, Mr. Roy, take out your wallet and give it to him. Matter over.
But let them hand over the vacant possession and give the rent for those periods.
What?
That for the rent, use the period for which they had utilized the rent. Let them give the rent and hand over the vacant possession of. the
Why
land.
vacant position? They've acquired, you said that they have acquired in
No, no,
1975.
they have not acquired. They are saying they have acquired, my lord.
You say that
Madam,
you
we-
have not
we
taken
say
into
that, my lord,
action because you were under the bona fide belief
Yes.
that they have acquired.
The reason for not approaching this court at that relevant point of time, that, my lord, we thought that it has been acquired, so we were asking for the documents. But when we couldn't find, my lord, in 2005, we have given a notice. Thereafter also, my
Supreme
lord,
Court may have stated out there, recently also have stated under 300A, but those are not cases where there has been acquisition, there is a step, question of acquisition. They may have lost. It is your duty. Have you paid the land revenue all this while? Show me. Show me. And now one fine morning, somebody wakes up, oh, why not?
2005, no. From
Don't worry,
2005.
we will take care of that judgment of the Supreme Court by taking into account the recent Constitution bench judgment also on the lane latches. Don't worry, we'll take care of that. Come up, because they may have lost those papers.
My lord, when they are saying that this 10 biga, 14 bigas, those document they
So
have.
these are the
So
10
is it-
bigas which they have
Yes,
taken.
so is it believable that only the document in respect of that 5 biga will be lost and everything will be there?
So these, out of these 10 bigas, this is the 10 bigas they are saying,
So that is why.
of which your the 5 bigas is
Now, my lord,
inclusive.
the report of the circle officer, who is the customer.
Wherever the report of the circle officer, read the circle officer main is not
Yes,
clear. Kindly
it
see
is-
that. No, Mr. Das, kindly see the affidavit which has been filed
Yes.
by
my lord,
the
by the
subdivision.
state, my lord, the state
Kindly
was
see
in
page 67, paragraph 5.
in
As
paragraph.
per the record of the response number 4, as per necessary
It is
hearing
saying
in
that
between the
so-and-so
petitioner
and
has called
so-and-so
for a
is
joint
in
survey
possession
and
of
accordingly in
CRPF
presence
authorities
of
since
the officials
1995
of the response number
constructing their
2,
water
4 and
pump house.
5 along with the petitioner joint inspection was conducted, and as per report it is seen that dark number 49 and 5 of Pata number 31 of Kolumatre is in possession of Iman since 1965, 75 constructing their water pump. Then you see then the next page,
Yes.
para 10.
Yes.
That with regard to the statements made in the so-and-so as per the records of 14 bigas of so-and-so village of land, of which 10 bigas at Horuhotura area have been allotted to the Iman by the acquisition number so-and-so.
Yes.
But in fact, the respondent have been searching documents, if any, per request issued by the area, but no documents have been traced out.
But para 8 lordship will see what is
Yes.
their affidavit, my lord. This from the middle, it is
Directly
stated
written 2 letters and so and
It
so.
is
It is
stated that-
necessary that the respondents have been searching documents
7
issued
from
by
7th line, my
Iman
lord.
so and so.
Para
But
8.
no document traced found in regard to dark number so and so which stands in the name of the petitioner. Further reallocated to the petitioner number, further reallocated to the respondent number 2 in this regard. The respondent number 4 have further inquiring into respondent for any other document in respect to the land have further reallocated to respondent from the petitioner in accordance with law or not.
7th line, para 8, my lord. From 7th line, it is
So
stated.
what? They don't have any documents because they have lost.
My lord, what they have said, I'll just read out, my lord. It is stated that since January 14, the respondent number 4 has
they
been
have lost.
searching
It
documents.
can't help it.
Since 14, my lord,
39 years, so delay.
since 14, my lord, they have been searching the
39
document.
years. 9 years. Delay.
There are cases where even after 42 years, my lord,
Show me
the
that.
apex court has
Show
allowed.
me that.
Yes,
Where the Supreme Court has given that.
my lord, the first judgment which I am relying is of this is this Tukaram Joshi, my lord. In this case, it has been held, my lord, that relevant paragraph, 2013 1 SCC 353.
Huh?
2013 1 SCC 353.
Age, paragraph.
Paragraph, my lord, 17. 1718. Depriving the appellant of their immovable properties was a clear violation of Article 21 of the Constitution. In a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon to rehabilitate such person. The non-fulfillment of their obligation would tantamount to forcing the said uprooted persons to become vagabonds and to indulge in antisocial activities, and such sentiments should be borne to the born in.
Everything is okay, but here paragraph 2 of the judgment. There is a categorical finding that the proceedings have lapsed.
Yes, my lord.
Then
He said this land, my lord, land.
oh, it has lapsed, so nothing. But here there is an acquisition proceeding rightly done.
But ultimately, my lord, the son.
No, here is an acquisition proceeding. You have your basic case is that you bona fidely believe that this acquisition was done.
Yes, but
Then
ultimately, when we found that.
Take
we
that
could-
money of how much?
And then, my lord, this
250 into 5.
74.
Then what is the next judgment?
2022 SCC.
What does it say?
Para 20, para 12.9, my lord. In a democratic polity government governed by the rule of law, the state could not be deprived of a citizen of their property without the sanction of law. Reliance is placed on the judgment of this court in so and so, wherein it was held that the state must comply with the procedure for acquisition, requisition, or any other permissible statutory mode. The state, being a welfare state governed by the rule of law, cannot arrogate to itself a status beyond what is provided by the Constitution. The court in the case of so-and-so held that right to property is now considered to not only a constitutional or statutory right, but also a human right. Human rights have been considered in the realm of individual rights, and such rights to the settler, livelihood, health, employment, etc. Human rights have gained multifaceted dimensions. We are surprised by the plea taken by the state before the High Court that since it has been
Yes, come to paragraph
42
two.
years, madam.
Paragraph 2.
The respondent state took over the land of the 1943 for construction of a major district road so and so for a major without taking recourse to acquisition proceedings or by following due process of law. The construction of the road was completed in the year 1970. Now, there is 40.
But here in the case, there is an acquisition.
But no acquisition of.
There's
the
an
petitioner's land,
acquisition.
my lord.
You also admit that there is an acquisition by filing your
So, but
acquisition.
that acquisition in respect of different land, my lord. Here is a case after 42 years, my lord. The apex court has said, my lord, the delay and net, my lord, and in this case,
Nothing doing.
2022-7 SCC, my lord, 508.
20?
22, I'm giving a copy, my lord.
508. Which one?
Para 18, my lord. Regarding delay and laches, my lord. Para 18. There is a welter of precedents on delay and laches which conclude either way as contended by both the sides in the present dispute. However, the specific factual matrix compels this court to weigh in favor of the appellant landowner. The state cannot shield itself behind the ground of delay and laches in such a situation, and there cannot be a limitation into doing justice. So, my lord, in other cases, after 42 years, my lord, the compensation has been given.
Here also, paragraph 2. Without any land acquisition
Yes,
proceedings.
but here is also land without any land acquisition, because for a moment your lordship will kindly turn to pay the affidavit of the state at para 8, my lord, from the middle, my lord, 7th line. It is
What is-
stated.
What does
They
it say?
say, my lord, it is stated that since January 14, the respondent number 4 has been searching documents issued, if any, in favor of the respondent number 2, that is the CRPF authorities, and it is found that the original allotment to the respondent number 2 has been made in DAG number 6 and 52 as per government letter dated so and so, but no document traced found in this regard to DAG number 5 and 49 of Patta number 31, which stands in the name of the petitioner. That they themselves is saying that the land which stands in the name of the petitioner, they could not trace any from 2014, my lord, 24 is going to end. They could not find any document, and they themselves says that this DAG number 5 and 49. No, it was not given.
They
to the-
could not file the document from 2005 to 2024 because of
But
the
this is
fact,
the
12 to
affidavit, my lord, which was filed in
2024.
2015,
Because
my
of
lord.
the fact you did not approach from 1975 to 2012.
This is a affidavit of 2015, my lord. From
Therefore, I'm
Yeah.
saying they have not been able to trace out because of that.
But last order, there is an order dated, my lord, I think in September. In September also, they could not, my lord, from 14, they are searching. There's and a direction was given to file an affidavit, what to do, my lord. So then also no affidavit was filed.
Yes, Mr. Roy. Who is paying for the CRPF? You show the land and vacate. Show the land documents that you have been acquiring this particular plot of land. Vacate it.
When verification by the state.
There is no question of joint verification. Joint verification has been done long time back. There is no quarrel that you are there. There is no quarrel from the affidavit filed by them that the land still vested, still is there. Unless there is a vesting by way of a provision, by way of an award, there is no vesting upon you. So under such circumstances, if the state or anybody cannot show, stands there. So when you are vacating,
Let it come after, on the first week of January, Lordship, let,
First of week of January, you vacate.
no, Lordship, let me
No,
have the
no,
instruction,
vacate
Lordship.
it.
Lordship, even
Let us see the vacant picture and give it to them. Water pump. What water pump you are doing with 5 acres of land?
if they have not on, in the repetition, Lordship, they are not paying the land revenue also, they should not say that they are paying the land revenue till late, Lordship.
You are paying for whom?
They are paying.
The state coming up out here that have any taken any action for non-payment of revenue? Have they gone for auction sale? Or is the CRPF going to buy out there? Let them first go for auction sale. They have not gone for auction sale. Then why should we go into all these things? Don't take I'm asking him the questions. That's a different thing. That doesn't mean that you come up with that. Oh, vacating. 3rd of January, you vacate, give us the NP position. We'll look into it.
Because there must be some documents because.
There's no
just an-
documents. 15
Lordship,
years.
let me-
10 years have gone by. You have no documents. Matter over. Vacate it. 3rd of January, I'm keeping it. Give us, show us the vacant possession of the premises. Appearing for the CRPF, na? Vacate it.
for
You
instance,
cannot have
let it
this.
be on- let me
You
have
are
the instruction.
protectors of people with the freedom and you resort to all hooliganism.
That cannot be, Lordship.
Absolutely. You have no business out there.
Lordship.
The circle officer asks you to come, you don't
Their
come.
acquisition
Does
is
it take
there-
10 years?
That only that we cannot produce the, but.
No,
the
no
state-
produce. No, Mr. Kindly appreciate. If it is an acquisition made under the 64 Act, this can't be at that point of time, the government of Assam did not go for a 64. This will be the 1894 Act. There has to be an award. If you don't have an award, no vesting. Buy from the petitioner in the meantime. We have a lot of money. Buy it. Isn't it that big building out there in Sunapur, the white building?
But
The
that is
SSB.
That is SSB. They are CRPF. They are CRPF. That is SSB. madam.
Okay.
This is.
Give that land to him.
We had the instruction on 3rd, I come with the instruction, Lordship.
Hello, September order was there.
The matter has been pending for the last 10 years, for a decade before this court, whereby the petitioner herein have assailed the actions of the respondent authorities of forceful taking over of the land of the petitioner at measuring 5 acres,
5 figures, 4 ledgers.
4 lectures covered by dark numbers 5 and 49 of patta number 31
31.
of village Horutari, Moza, Hunapur. Pusto. The affidavits which have been filed by the respondents, more particularly the revenue authorities, categorically show that the dark number 5 and 49 of patta number 31, and more particularly the land being dark number, measuring 5 acres, 4 lectures, is in possession of the CRPF since the year 1975. But but the said land still stands in the name of the petitioners. There is also nothing on record shown that the land have been acquired in spite of a passage of 10 years have passed pursuant to the notice issued by this court. It is a well-settled principles of law that the state, under no circumstance, state or its functionaries cannot appropriate the land of a private person without following the due process. In the instant case, it prima facie shows that the respondent authorities have usurped the land of the petitioners without following the due procedure. Under such circumstances, for the interest of justice, an additional chance is being given to the respondent authorities to produce any document to show that the land belonging to the petition, the land of the petitioners in dark number 5 or 49 and 49 or patta number 31 at measuring 5 bigas 4 lectures have been acquired or taken over by following the due process. Failure to do so, this court shall have no other option but to resort pass appropriate directions. This is matter on 9th of January 2024 at the top of the list, showing it as part of.
Let it be a fifth lordship.
What?
My friend says 9th, she will not be there.
How many CRPF persons and lawyers you require? You are one,
Lordship, I am
she
not
is
appearing.
one, have another 3, 4.
Lordship, I
Call
am not
Mr. H. Gupta, he also appears. You call Mr. D. R.K. Dev Chaudhary, he also appears. All of you stand up and appear.
Item 44, order no state.
Yes, withdraw. Withdraw.
No,
Let to withdraw. Because of the fact that you say that the respondent number 6 is vacated, so your entire cause of action was on respect
My
of
lord, I
this.
have the instruction that, my lord, Dilip Rajbangshi is not there now, my lord.
Huh?
Release Ram-
Then nothing remains.
is not there, my lord. But land is there, my lord.
So what? That is really a separate cause of action.
My lord, my only pair would be, my
That is
lord.
a separate cause of action,
There
Mr.
will be the
Tipulas Rahman.
interaction, my lord, between the municipal corporation and the DC, my lord.
Huh?
Let there be an interaction, my lord, with the DC and the.
Absolutely no. First of all, your entire cause of action is the respondent number 6 has encroached this land. Now you say the respondent number 6 is no longer there. So that meaning thereby that your entire cause of action is not there. It will be some other person. So therefore, how do you maintain your petition? Therefore, heard Mr. Tripulas Rahman, the learned counsel appearing on behalf of the petitioner. Ms. Udas appears on behalf. The learned additional senior government appears on behalf of the respondent number 1 to 5. The petitioner herein has approached this court alleging that the respondent number 6 have encroached on the width of the road and thereby have narrowed down and thereby have caused of have width of the road, namely Sohit Park, and thereby narrowed down the same. During the course of the hearing, the learned counsel appearing on behalf of the petitioner had submitted that the respondent number 6 is no longer in possession, is no longer in occupation of the land and is no longer in occupation of the land, including the encroachment to the Sohit port. He, however, submits that the order so passed by this court dated 1/4/2019 in WPC number 2514/2017 have not yet been complied with. So taking into account that the entire cause of action of the petitioner was on the basis of that the respondent number 6 has encroached the Sohit port, and the respondent number 6 is no longer in possession. The entire cause of action of the instant writ petition has failed. Accordingly, this court is not inclined to issue a writ in the instant proceedings. Be that as it may, if the petitioner is aggrieved by any obstruction so caused to the road in question, the petitioner would be at liberty to approach the respondent authorities, who shall duly take note of its objections as well as the order so passed by this court dated 1/4/2019 in WPC number 2514/2017. Accordingly, the petition stands disposed.
Above the list, item 43.
Yes, you being the top of the list, it went to the bottom of the list.
That I was asking, what will be about the bottom of the list? Those are in bottom of the list.
I have the top of the list, then there is also at 2.
Okay, Lordship, there is a judgment of your Lordships, that is Lokripriya Soikia versus State of Assam and others. Where also Lordship has dealt with it, but it was not discussed in between. But ultimately that was taken into consideration that it cannot be retrospective effect.
Did I say that?
That discussion is not there. In between the law has not been discussed here, but another judgment.
Yes, others may go. Hmm. We have been successful in getting the PETA matter done. I think you should be happy for this year.
Oh, my language print is also here. I have given the office copy. Instead of the court's copy, I have given the office copy.
Yeah.
Highlight as it.
Which one?
Airtel matter, item number 5.
For that matter, where the other, what Kotoki is there? That one? Is that the matter? Kotoki is there? Oh, that one. Now, what has happened to the division bench matter?
Yesterday the matter was before division bench.
Go for so.
That division bench has disposed the matter to be heard. Request is being made to the learned single judge to hear this matter. In the meantime, that particular the order which has been your lordship has passed para 27, that has been maintained by the division bench. They said that it will continue and the matter can be disposed of.
Meaning they were?
That is kept in abeyance.
Till my lord, dispose of this writ petition, my lord, and directed to decided man on merit, my lord. Regarding that para 26 is concerned, my lord, that
Is it the opinion of the division bench that the single bench has not decided on merits that day?
So regarding 26 is concerned, my lord, this honorable court is directed to the State Bank, my lord, to release that amount within 10 days, my lord. Then, my lord, SBI has, my lord, approached before the division bench, my lord. And that court was yesterday disposed of the matter, my lord, with a direction, my lord, to keep an abeyance, my lord, para 26, my lord.
Then? Okay. In peruse the order being passed by this court, that is since release from parted.
My appearance, my lord. I am appearing for the respondent 6, 7, and 8, 9.
My lord, item number 3 and 4 is parted. Lordship may take up this matter on 7th, my lord, that date.
Item number 3 and 4. For these matters.
7th.
Oh, you have a bad case.
Still.
Okay. Taking into account that the matter has been kept parted for a long time, the item number 3 and 4 is released from parted.
In para 41,
Hello?
41 and 42 in the original judgment.
41.
There,
No, here is different. You can't apply this judgment of a SAP because you see, compulsory retirement normally is not a case whereby you impose a punishment of it's a punishment. It is, however, in this case, it is a punishment.
Yes.
So therefore, the
other
question
judgment I have given-
arises. I complain.
Lordship, in the other judgment I have given,
Ah.
that is only one judgment, my office copy has also gone there. And in that judgment, there are two parts. One is regarding the amount of the quantum of the penalty, and other one is the regarding retrospective effect. The retrospective effect part was held to be illegal. Other one upheld, compulsory retirement was upheld, but the retrospective effect was held to be illegal.
We will have this again on. This is not. You see, there is a recent judgment. Then I think I need to find it out.
Lordship,
It's a very recent judgment on this point.
I have seen the judgment, but what happened, that I was having a copy, I have lost it.
Huh?
I have lost the copy where
The
I
recent judgment you
yes,
have looked
Lordship.
into, no?
When it came in the live law, I have just collected the judgment for this case only, but I have lost that copy.
It was by Justice D.Y. Chandrachud was there. I think Justice Pardiwala and Manoj, Justice.
Three judges.
I think three
That I
judges.
remember, but others,
Okay. Let's
I'll
have
find
it
it out.
on Thursday.
I'll find it out.
List this matter on Thursday at the top of the list.
I take your Lordship's indulgence in respect of item number 40. This matter has been long pending. Only my humble submission is that the matter may be fixed on a particular date. It is pertaining to the land belonging to the petitioners that was been demolished and consequences that followed.
Which one?
Item number 40. It's an old matter of 2000.
Those matters. Is it that matter where the land belonging and the Coal India has
Yes, your
done
Lordship.
that?
Lordship has rightly recollect. After a long gap, they had finally filed their affidavit in opposition by the government. So only thing a date may be
Let's
fixed.
have this matter on 9th of January.
9th.
So let this matter be listed on 9th of January 2025 at the request of Mr.
Obliged.
Item 37, may I pray for a date?
Why?
Item 37.
Don't ask for dates. I'm going to take criminal bench, so don't give me all these things. Where is 32?
37. Order matter.
Where is there? Matter again on 8th of January 2000.
Deeply obliged.